Please.
Your Lordship, two probate matters have been filed for letters of administration, Lordship. Petitioners are senior citizens. The estate assets are getting depleted and deteriorated. As such, the matter
What
may
they
be.
filed?
Pardon?
Which year is,
21.
we'll see, it is practically not possible for the court to, hear these many matters. Already every day there are about 50 matters which are date given by the other bench. And again adjournment, they're adding one more. See the list, today is 80 is the list in a final hearing matters. Not possible this week or the next week. Yes, next we'll see.
My lord, this
Yes.
is MF is of the year 2017, my lord. The claimants are aged about 70 years, my lord. They have not received a single penny, my lord. Accident is of the year
Every day 13 matters, 14 matters are listing and all the advocates wants time. What is the fun of listing the matters?
2017.
You will ask for a slip and other side will ask time.
No, my lord,
What is happening?
no, my lord, is of the
Is this matter
2017.
next week?
Please.
Anita?
wait.
Yes, next.
Page was
20 meters, 20.
please memo secretary sir, we should accommodate the date. Withdrawal. Withdrawal.
That will be called.
I will call.
Yes, next.
Page wise
Lord.
adjournment.
Transfer petition for fresh matter, my lord.
All the fresh matters without office objections or complaint, they will be listed. It's a direction from the court.
Please.
That no slip is required.
Please.
Yes, next.
Page wise adjournment, list one, page one, serial number 1, page 2, 2, 3, page 3.
Serial number 7, my lord.
Yes.
1 week time.
Why?
Translated copy. my lord.
We'll look at it. How many times you have asked for the time? We'll impose costs and grant time. I think it is high time that the
That's
court has to
only
take a
one week.
serious note of it.
1 week.
Everyday matters have to be listed and adjourned. I'm not able to understand that. If you're not interested,
Senior,
issue notice to the.
Lordship, senior is not-
Issue notice to the client.
not feeling well. 1 week, my lord. Please.
Every day this happening, court is also not feeling well.
Any date fixed, my lord.
Why should it be? Why should it be adjourned every day? Take out that, this item number 7. When there was a direction, how many times this matter is adjourned? Yes. Call the next matter and ask him to take it out. Yes,
The page number 4. Serial number 9 to 11. Page number 5, 12 to 14.
14, Lordship. Serial number 14. I am respond number 1 and 3.
Respond
number 1 and 3, Lordship.
yes.
My lord, they have filed an application for production of additional documents, Lordship. I have to file objection. Please press one week time, please.
Finally, a week's time is granted for filing objections on IA number 1 of 25.
Please.
No further time will be granted. Next.
Okay.
Page number 6, serial number 15 to 19. Page number 7, 20, 22. Serial number 8, page number 8, serial number 23 to 25. Page number 9, 26, 27. Page number 10, serial number 20. List number 2, page 1, serial number 1. Page 2, serial number 2 to 4.
4, my lord, I filed a memo.
You want to withdraw?
Withdraw. Does not survive for consideration since respondent is dead.
In 4, the memo is filed stating that the cause of action, stated the petitioner is no more. Died.
Respondent.
Respondent is no more. And died on 12/1/2025. Is the cause of action not survived accordingly. Same is dismissed as infectious.
My lords, serial number 3, my lords, list 2. Both the parties didn't turn up, my lords, even the trial court. List number 2, serial number 3, my lords.
Sir, PS.
Yes.
Oh.
Both the parties didn't turn up, my lords, even the trial court advocate also, they didn't turn up.
I didn't understand.
The parties have not reached us, my lords, even making a lot of several attempts in contacting them.
In spite of giving sufficient opportunity for filing necessary application to issue notice to the respondent through substituted service. This application is not filed. This is a transfer petition of 2022. Land counsel for the petitioner submits that in spite of his best efforts, he could not get instructions from the client. Accordingly, the petition is dismissed for non-prosecution. Yes.
Page number, Page
Serial
number-
number 6, my lord.
page number 3, serial number 6.
Serial number 6, in this matter, I need one short accommodation. In this matter, what last time lordship heard the matter. After that, the government has filed a memo stating that they have taken over the possession of property based on the government order. I have to convey that to my client. Client is not in India, he is in abroad. I have to send a mail. At least 2 weeks time may be granted, my lord.
My lord, memo.
When this matter was adjourned,
Matter by was.
from now onwards, for
Yeah,
each
yeah.
adjournment, for each time the matter is listed in the
By
cost
was.
list, 500 for each adjournment.
No,
Cost of 500 for each adjournment.
but 7, after that it was not listed, my lord. It was heard on 7/1/20.
So MSA will be heard by the court and we'll spend substantial time on that. Thereafter, adjournments like this.
Reason is that only thing is I may have to withdraw this matter if it is,
Do it.
but for that I need signature. of the-
Finally, a week's time is granted, no
Yes.
further time.
One submission, my lord. Memo filed by the government,
Huh?
served to me, my lord. I am for the respond 1 to 19, my lord.
He is the contesting respondent.
That is filed on 9/12/24.
They are not served, my lord.
Without serving you, they have filed the memo.
Yes, my lord.
So serve the copy on him.
Please, I have objection on that, my lord.
A week's time finally.
Please.
Next,
Sir,
no further time will be granted. Yes.
Page number 4, serial number 7, page number 8,
My lord, serial number 8, my lord.
page number 5, serial number 9 to 10.
My lord, serial number 8, my lord. My lord, I appear for the appellants. It's for taking steps against.
Huh?
I appear for the appellant, my lord. It's for taking steps against the elders of deceased.
For this, no,
My lord, we have filed the applications, my lord. It will be.
we'll look at it. We'll look at it, what's happening in that.
It may not be put up today. I filed it yesterday evening and I apologize. My lord may fix a date so that it may be put.
No,
up.
no, no. We will
Next
look at
week.
we will look at the proceedings, the order sheet, what has happened, why, how many times this matter is adjourned.
My lord, last-
Why should the court accommodate and waste the time on this?
This
No,
week
you
itself.
please wait till the matter is called. Yes, next.
Page number 6, serial number 11 to 13, page number 7, 14, 15.
My lord, serial number 14, my lord. For the appellants, regular counsel father has been expired yesterday. Pray for adjournment on Monday.
What is that?
Regular counsel, no, GB Nandish Gowda, my lord. His father expired yesterday, my lord, and pray for adjournment.
At the request of, it is submitted that the arguing counsel is no more. List this matter when?
Monday, my lord. Next week,
List this matter after 2 weeks.
Page number 8,
judgment.
page number 8, serial number 16 to 23.
My lord,
Okay.
serial number 17. Request for 1 week's time and all.
Why?
that.
I
There is a-
represent respondent. The mediation negotiation is going on, my lord. Kindly. Mediation negotiation, ready to order.
No, why can't the mediation go on before the trial court also? Transfer pit
Hence-
stay, why should it be pending here?
My lord, the week's time, concerned council is.
All these, on all these transfer petitions, no time, whatever mediation, whatever that has to happen will happen before the trial court. The matter will not be kept pending before this court. Yes, next.
Page number 9, serial number 4. List number
Call.
number 3 for final hearing matters, page 1, page 1, 1 and 2.
My lord,
Page
seal number
two.
1, my lord, seal number 1 in connected matter, my lord, 75. The appellant was died, my lord. Earlier, this appeal is disposed of and thereafter the respondent filed the review petition and it is restored now. The appellant in this appeal is died, my lord. They have to take bring the LRs on the record.
When he died.
Lord, he is died in the long, this appeal is disposed in the year 2018, my lord. Now it is.
When was it reviewed?
It is, review is allowed last year, my lord.
Then at that time you didn't bring it to the notice of the court?
They have brought down in the connected appeal, the LRs on brought on the record, my lord.
No, any order that is passed against a dead person, what is the consequences of it?
My lord, because this is the claimant's appeal for enhancement of this appeal is I filed this for enhancement. Another is the insurance is filed for the liability, my lord. If it is the appellant to be brought on the record on this, because we already they are on the record in the connected appeal.
No, what is the order that is reviewed?
You, my lord, this appeal is allowed in part.
Which appeal is allowed?
This 75, 21 of 2011 is allowed. This is the another appeal is connected one
Please don't confuse the court. Which appeal? Appeal by the claimant is allowed,
Allowed.
enhancing the compensation. As on the day, claimant is no more.
As on the day the claimant was alive.
Then what is reviewed now?
The appeal that allowed, appeal allowed by the claimant filed by the is allowed. And the insurance filed the review petition in 376 of 2014. Thereafter, that review petition is allowed on 22/2024. Restored this appeal for fresh hearing. In the meantime,
What I'm saying, as on that day, no notice is issued to you. Have you appeared before the court or not? Was it brought to the notice of the court that the appellant is no more?
in the review petition, but this appeal is not restored.
Then what is that, what is the sanctity of that order in a review against a dead person?
Brought on the records of the LR.
Then why have you not done it in your MFA?
This appeal is not restored at that time. Madam. It's the first time this appeal is posted along this.
Very unfortunate, this court is still have to grant adjournments in a 2011 MFA.
It is posted before the court.
When was the order in the review?
Review order passed on 22/2024. Madam.
Then what are you doing from the last 1 year?
Hello.
Without bringing the appellant on record? The LRs?
Thereafter, this appeal was not posted.
It is not necessary that the appeal should be posted. It is for you to file the application, then the appeal will be listed.
It's the first time the appeal is posted along with this main appeal.
Finally, a week's time is granted for bringing the LRs for filing an appropriate application, or else the appeal shall stand dismissed. Yes, next.
My lord.
Respondent 3 is
My lord.
died in this appeal.
Huh?
Counsel of the respondent number 3 is the.
R. Rajagopal.
My lord, list,
Respondent number 3 is the driver of the vehicle, owner of the
He
vehicle.
is the counsel of the
That's what he is, the owner of the vehicle.
respondent insurance company counsel who represent this appeal is also died, my lord. I directed my learned friend in the connected. appeal.
Mr. It is submitted that Mr. P. Rajgopalan,
R. Rajagopalan.
R. Rajgopalan is no more.
I am filing.
Mr. M. Venkatesh is directed to take notice on behalf of the insurance company. Yes, next.
my lord,
Page number 3 to 5. Page number 3, 6 to 9. Page number 4, 10 to 14. Page number 5, 15 to 17.
15 may be taken up next week. ma'am.
Five.
My lord, I have got an appointment with the doctor, therefore I have to.
Your colleague will be there.
No, my lord, I have to argue this. matter. Therefore, I'm requesting.
Please.
Well, actually, I have
ask
the Monday
these
after-
matters.
Monday
Monday
after.
finally,
Monday
at the
after.
request of,
Thank you.
Counsel for the appellant in connected.
it is 15 or 16, he said.
15.
15.
15.1.
My appeal is also there.
Yes, next.
Page number 6, serial number 18 to 22.
22, same, Monday after.
Yes.
Page number 7, serial number 23 to 25.
My lord, serial number 25, notice to be ordered,
Hmm?
because it is not admin order. KSRTC.
25, N. Gopal Krishna for appellant.
I'm not able to understand what is your submission.
Sir.
9, serial number 1, list 1 of 25, my lord.
This list number 3, sir.
Sorry, my
List
sorry,
number
my
3,
lord.
serial number 25.
Yes.
Page number 8, serial number 26 to 28. List 1.
Where is the other side?
Kumar KG.
It is submitted that the compromise talks are going on, list this matter on August 20th. Interim order earlier granted is extended till then. Yes, call the list.
List number 1 for parted matter, serial number.
my lord, submission, my lord. List number 2, serial number 14 as mentioned as arguing counsel has been died, but his father has been expired, my lord.
Yes.
Father of the argument.
Obliged, my
List number 1, B.A. Ramakrishna for appellant. Chetan B.
Appeal for the appellant in this case.
Yes.
The crux of the matter is married daughter, married son, major son, whether they are entitled for compensation.
You were saying that the Supreme Court said that they're entitled for. Yeah, one more copy. Can you give me? Yeah, the next slide, put it down, what was the legislator?
Para number 6 onwards, my lords.
What is the law laid down in Birendra's case? Take that. No much discussion in this judgment. No much discussion in this judgment.
That's why, my lordship, National Insurance Company versus Birendra case in detail. Para number 13.
No, in Birendra's case, the finding of the court is at the relevant point of time, though they are major children, they're residing with the deceased, and they have they have a meager salary, and they are depending. And in those circumstances, this was, and anyhow, in this judgment, there is no much discussion on that, about how court had only taken that they're drawing some 1 lakh or so, the salary. What do you say about the legal portion?
Can I request your lordships to turn to the paragraph 10 of this particular judgment? Let us.
Paragraph 10 of the
Civil appeal number 23, 23.
judgment.
Seema Rani's case.
Seema Rani's case. Yes.
Adverting to the facts at hand, on a perusal of the statement of Shashi Kumar, the son of the deceased, appellant number 2 herein annexed as annexure P6, was working at a petrol pump while the other son was involved in temporary employment opportunities. Both of them were residing with the deceased. What is the evidence that is adduced now? In this case, the evidence of
Who are the
PW1,
dependents? Who are the dependents in this?
the evidence of PW1,
No. The dependents are son and daughter.
1 daughter, 2 sons.
married daughter,
Daughter and 2 sons.
married daughter married about 10 years back.
What is their age?
Age is-
Second, 35 years, 33 years and 31 years.
What are they
That-
doing? What are they doing?
Lordship, second petitioner is.
Please come to the order.
Please.
Paragraph 26 of the judgment, trial court judgment.
Please read.
In the cross-examination of PWN, he has stated that his sister was given in marriage about 10 years back, and he is also married about 8 years back, which goes to show that petition number 2 and 3 are married, and petition number 2 is residing in their matrimonial house, and petition number 3 is also married, and leading his independent life by maintaining his family, and they were not dependent upon the income of
Number
the
1 and
deceased.
4, 1 is the wife,
Second
four
is the daughter, married daughter.
4, 4.
4 is the 26-year-old son.
That's why 1/3 is deducted.
Please.
So please tell the court what is the evidence to show? What is the evidence to show that you're relying on judgment of this Seema Rani? Yes.
Can I?
What is the evidence that is placed before the court?
Cross-examination portion of PW1. In Kannada, I will read. ನಾನು 8ನೇ ತರಗತಿಯವರೆಗೆ ಸ್ಟಡಿಡ್ ಅಪ್ 8th ಸ್ಟ್ಯಾಂಡರ್ಡ್. ನನ್ನ ಅಕ್ಕ 1ನೇ ಅರ್ಜಿದಾರನು 10 ವರ್ಷದಿಂದ ಮದುವೆ ಮಾಡಿಕೊಡಲಾಗಿದೆ. My sister was married about 10 years back. ನನ್ನ ಮದುವೆಯಾಗಿ 8 ವರ್ಷ ಆಗಿದೆ. Married about 8 years back. 4 ಅರ್ಜಿದಾರ ಲಗ್ನವಾಗಿರುವುದಿಲ್ಲ. Second son is not married. ನನ್ನ ತಂದೆ ತೀರಿಕೊಳ್ಳುವಾಗ 55 ವರ್ಷ ವಯಸ್ಸಾಗಿದೆ. Was about 55 years. So except this, no other evidence. I mean, in the cross-examination, I will elicited the information that
PW1 is examined.
Please.
PW1.
Yes. So then on what ground you are before this court?
Have come before this court on the ground that it should have been, since the tribunal has held that claimant number 2 and 3 are not dependents at paragraph 26 I have read. Then 1 and 4 are dependents. 1/3 is deducted. I said 26-year-old son, 28-year-old son is also not dependent. It should have been half.
Anyway, that I think I
No,
have.
that is my contention.
That's it. That's the only ground.
Yeah, that is one ground. The other ground is I filed an application for additional documents at page 45, 46, 47 of my appeal.
45.
That is the ration card copy. I have been able to lay my hands after the judgment. It was issued on 10/4/2009. At the time, the age of Hiran Shetty deceased was 50 years. If that is considered, he would have been 55 years. The multiplier should have been 11, not 13.
What do you say on this point?
My lordship, I produced a document for my election card, my lordship. As per the election card, my lordship, the date of birth of the deceased is 10/11/1965. The time of accident is.
As per their document, what is the date of?
This is under which they were drawing the ration for the entire family.
No. This 49 document, what is the date of birth?
10/11/1965. As per the election card.
As per the card which he is relying on.
10/4/2009 at the right hand bottom.
No. Date of birth.
Age is
Date of birth ಕೇಳ್ತಾರೆ.
date of birth, that is not mentioned. The age is mentioned as 50 years Hiran Shetty.
In election card, date of birth is mentioned.
10/11/1965.
So these are the two grounds.
Yes, 2 grounds.
Yes, yours enhancement is on the ground of
And-
dependency.
Dependency and.
And
Dependency trade court already taken.
Come to that table.
Please.
then
Tribunal has taken.
one other submission.
No, 1 minute.
Page 51 of my appeal memo.
Hmm?
Page 51 of my appeal, that is other document. The wife was, that is at page 51. Wife was aged more than 50 years as on the date of the accident. Her date of birth is
Date of birth is
1163.
1/1/1963.
1163.
How can he be 10/11/1965 husband?
her age is, the date of birth is 1163, it should have been definitely more. Unless they say that
Documents of.
she was
No,
elder to him.
no, as it is mentioned in the Aadhaar card, if it is
Wife,
Wife's
wife's,
50,
1163,
wife's date of birth.
date of birth.
that I have seen, according to you, at page 40, as per page 49, his age is how much? As on that day, what was his age?
What, on the date of issuance of this card, he was aged 50 years. It was issued in 2009 April,
So that means is
55 years.
as per that, his date of birth should have been,
There is no date of birth mentioned.
No
in
date
this.
of birth is mentioned in the ration card.
I'm asking you to count on that, basing on that. 2009. That's fine. He's 50 as on that day.
Yes, 55.
50?
5. Age of the deceased would have been 55. He gets supported by the other document at page 51, the Aadhaar card of the wife. Age of the wife is 1163.
ಅವತ್ತು ಇಶ್ಯೂ ಮಾಡಿದ ದಿವಸಕ್ಕೆ ಎಷ್ಟು ವರ್ಷ ಅಂತ ಕೇಳ್ತಾರೆ ಅವತ್ತು ಇಶ್ಯೂ
ಅವ್ರದ್ದು booked date of ದಿನಾಂಕ ಬರ್ದಿರಲ್ಲ.
ಅದಲ್ಲ ಅವ್ರದ್ದು
Date of birth.
What do you say then?
As per the election identity card, my lordship, the correct date of birth was mentioned, my lordship. Up to deceased, that is 10/11/19.
No, they have filed an application under order 41 rule 27. Have you filed your objections to that? You have not filed your objections. Then as per the this Aadhaar card of the wife, her date of birth is 1963. Then what is then we have to take into consideration the other one also. Election card, it shows 1965.
Date of
It
birth,
can't
the
be, it is
deceased.
not your case that the husband, the wife is, elder to the husband. You have not filed your objections to that. And we have to consider his submission.
Regarding income, my lordship.
Please come to the, so what is the income?
Tribunal has taken 5,000, my lordship.
Which year is the accident?
Up to 26/9/2014 is the accident.
What should be the income?
8,500
8,500.
plus
Yeah.
future profit may be added.
What is his age?
As per the election card 14 and date of
55 years,
55 years. Then what future prospects would be 10%.
10%. Multiplier is 11.
One third has to be deducted.
Please.
That is 3,116. Six, 2, 3, 4. What is the multiplier?
11.
11. Comes to 8,22,000. 888. This is loss of dependency.
Please.
Medical expenses, no dispute.
No,
29,579. Loss of love and affection. How many are the wife and 4 children?
one wife, 3 children.
3 children. 3 children.
Please.
That's total 4.
Please.
It comes to 1,76,000.
at 44.
Hmm? Funeral expenses, 31,900. 36,000 is the funeral expenses. Lower court has awarded 11,34,579. Now it will come to 10,74,467. Ten lakh 64,467 it will come to.
Loss of estate is 1 lakh.
Uh,
Tribunal has given loss of estate is 1 lakh rupees.
No, it is, there are no loss of dependency, 8 lakhs, medical expenses 29, loss of love and affection, 1,76,000. Funeral expenses 36,000. It comes to 10,64,467. Please come. Agreed with the order, passed in. ABC number 1054 of 2015 dated 5th January 2017. Both the claimant as well as the insurance company are before this court. Insurance company's appeal is MFA number 7403 of 2017 and the appeal of the claimant is MFA number 2772 of 2018. The claim petition is filed seeking compensation of an amount of rupees 28 lakhs for the death of the deceased in the accident. It's a case of the claimant that on 26/9/2014 at about 8:30 PM, when deceased was going from his village to market at Chandraipatna town by walk on the left side of the road. At the time, the right of the Hero Honda bike came in a rash and negligent manner and dashed to the deceased. In the said accident, the deceased sustained injuries, grievous injuries to his head, nose, and hands, and his right leg was fractured, and he sustained grievous injuries on other parts of the body. He was taken to the. He was admitted in the hospital. The deceased has succumbed to the injuries on the way to the hospital. The claimants are 4 in number: wife, a married daughter, a married son, and another son who is unmarried. As per the claimants, the deceased was working as a driver. What is his occupation?
Agricultural work. That's an
Agriculture and mason work, and earning how much?
30,000 per month.
And earning 30,000 per month. The tribunal has held that the accident had taken place because of the rash and negligent driving of the driver of the Hero Honda motorcycle, and as the same is insured with the respondent insurance company. And it is held that the insurance company is liable to pay the compensation. When it comes to the compensation, the court had considered the income at
7,500.
Huh?
7,500.
had considered income at 7,500 and taking into consideration and considered petitioner number 1, the claimant number 1 and 4 as the dependents, and 1/3 was deducted, and an amount of rupees 7,80,000 was granted towards loss of dependency. Funeral expenses Funeral expenses of an amount of rupees 25,000. Medical expenses 29,579. Loss of love and affection, an amount of 1 lakh. Loss of estate 1 lakh. Loss of consortium. What are all these heads? Tribunal, what are all these heads? Loss of consortium 1 lakh. Loss of dependents, altogether a compensation of 11 lakh 34,000. 579 is 11 lakh 34,579 is awarded. In the appeal that is filed by the insurance company, an application is filed under Order 41, Rule 27 to show that the date of birth of the claimant number 1 is 1/1/1963. And as per the Aadhaar card, as on 10/4/2009, the age of the deceased was 50 years. And as on the date the accident had taken place, his age is 56 years. His age is 56 years, but the tribunal had considered 50 years
50.
basing on the election card. 49 years basing on the election card. No objections were filed for the application filed under Order 41, Rule 27. If the contention of the learned counsel for the claimant has to be taken, that the date of birth or his date of birth is 1965. The Aadhaar card of the wife shows that her date of birth is 1/1/1963. It is not even the case of the claimant that she is elder to the deceased, and no objections are filed. Considering the same, the application filed under Order 41, Rule 27 is allowed. And the wife, basing on the Aadhaar card of the husband, his age is taken as 56 years. Then coming to the income, there is no income, there is no evidence available on record. The court had taken 7,500 as income. As per the table, this court is inclined to take, as an accident has happened in 2014, the court is taking the income at 8,500. 8,500, 8,500. Then coming to then the multiplier is 11. Coming to the dependency, the tribunal has held that only 1 and 4 are the dependents on the deceased. Learned counsel for the claimant had relied on the judgment of the apex court in case of Seema
Rani and others. Civil Appeal number 23, 23.
In case of Seema Rani and others, reported in 2025 INSC 192, that is Seema Rani and others versus the Oriental Insurance Company Limited and others, wherein the apex court had considered the major son as dependent, major son and daughter also.
Yes.
And daughter also as dependents. Relying on this judgment, the learned counsel submits that the court ought to have considered all the 4 as the dependents and ought to have granted the compensation. It is submitted that the Honorable Apex Court has also considered the judgment of the Apex Court in case of Birender, that is National Insurance Company Limited versus Birender and others. When it comes to the dependency, the judgments that they are relying on, either in Birender's case or in Seema Rani's case, referred to Supra, there is sufficient evidence on record to show that though they are major, but they are still depending upon the father. Whereas in this case, there is no such evidence. Hence, the judgments either in Birender's case or in Seema Rani's case do not apply to the facts and circumstances of this case. In the considered opinion of this court, the trial court had rightly considered the dependency and rightly granted the compensation. And the court The court had granted the compensation under law of affections, loss of estate, loss of consortium, and different heads. And those also requires interference from this court. Hence, this court is granting the compensation as per the table given below. The income is taken at 8,500, considering his age. The future prospects is 10%. That is 850 would come to 9,350. As there are two dependents, 1/3 has to be deducted towards the personal expenses. That is 3,116. And the contribution of the deceased to the family is 6,234 into 12 into 11. Loss of dependency would come to 8,22,888. The court had granted medical expenses of 29,579. And no interference is called for. Towards loss of love and affection, that is towards consortium, 4 into 44, 1,76,000. Funeral expenses, 36,000. Altogether, it comes to 10,64,467. Accordingly, the appeal of the insurance company is allowed, partly allowed, and compensation is reduced from 11,34,579 to 10,64,467. The appeal of the claimant is dismissed. Yes. If this. Yes. List, I think.
Plaintiff's
List.
petition,
List.
suit for declaration and permanent injunction, my lord. IA under 39 rule 1 and 2 was filed. The trial court allowed the IA, MA was preferred, reversed, and now writ petition not seeking, challenging the order passed in MA. But this honorable court on my lord 19/9/2019 granted status quo.
No, 1 minute. You said what is the suit for?
Suit for declaration and permanent injunction.
You're the,
Plaintiff.
what has happened to the IA?
IA is allowed in trial court,
Appellate court had reversed it.
reversed it. Challenging that, I approached this honorable
Oh.
court. On 19/9/2019, status quo was granted, which is in operation till this statement.
Hmm.
My respectful submission is that, my lord, that may be continued.
2019 is the status quo.
Please, my lord.
What is the stage of the suit now?
Still to hear on maintainability.
Huh?
Still to hear on maintainability of the suit. Not even written statement.
My lord, prior to filing the suit, my lord, the petitioner has filed a suit for permanent injunction. Prior to
For?
filing suit for declaration and permanent injunction, this is a suit for declaration, permanent injunction, my lord. Prior to filing the suit, my lord, the petitioner had filed one more suit, that is suit for permanent injunction. With respect to the permanent injunction, my lord, the suit has been dismissed. The suit has been dismissed. With respect to the possession, it has already been determined that the petitioner is not in the possession of the property. Now, my lord, we do not dispute that with respect to the extent, but with respect to the boundaries, we are disputing, my lord. That is, the to the southern side of the plain schedule property, there is 20 guntas of land, which is exclusively reserved for the cremation purpose, where villagers are using. If the status quo continues, my lord, more than 600, 700, more than 1,500 people are there representing the community. And if they are not able to, and if they, with usage of the
In
status
respect
quo,
of the very same burial ground, which is like
Please.
part of the earlier suit schedule,
please, my lord.
that suit was dismissed.
Yes, please, my lord.
Where is that?
My lord, at page number 51, my lord, of the writ petition, there is findings recorded by the land appellate court, land miscellaneous idralli. My lord, I will kindly permit me to read it, my lord.
When was that suit dismissed?
My lord, it is a 2008 suit, my lord, 2006 suit, my lord. It has been dismissed and it has attained finality. We
When
do
was
not
it
know-
dismissed?
We do
You
not
don't
know
have
the
the
exact date, my lord.
Yes. When was this suit filed?
2006, my lord, earlier suit.
Present suit?
Not present suit, earlier
2015.
suit.
I'm asking you, when is the present suit?
Present
It is
suit,
in
my lord,
2016, my lord.
2016, my lord.
So for the very same property, you have filed a declaration now.
Please, this is
And now you-
comprehensive suit.
Correct,
Previous
it's
one
a
was the-
comprehensive suit, but the suit schedule property is one and the same.
It's the
And
same.
your suit for injunction is dismissed, holding that you are not in possession of the property.
Yes, your lordship.
Holding that boundaries are not matching.
So the same applies now, the same thing you have filed now also.
No, my lord, the difficulty is that in the guise of accessing the crematorium or whatever, the entire extent of 5 acres changes, my lord, being interfered with. I'm not in dispute of the 20 guntas kharab. The dispute is
So
that
in that case, you should file an appropriate application in that regard.
I filed for the entire extent, not only 20 guntas, my lord. Their dispute is in
My lord.
respect of only 20 guntas. Now my,
That's what I'm saying. In that case, you should have restricted that, apart from the 20 guntas, you should have sought for injunction.
no, my lord, I filed for the entire extent.
And then in that case, it can't be.
Lord, in that case, my lord, it may be recorded that my land, which is not
So
in
you
dispute.
are only concerned with that Karab land of 20
Karab land,
guntas.
yes,
Please
your
go ahead.
It's a purely
We are
government
not
land, your lordship.
disputing the extent of the petitioner, but with respect to the 20 guntas of land, my lord, I am concerned with that 20 guntas of land, my lord, because, my lord, the villages, my lord, there are more than 2,000 people and ST people are residing. And in view of the status quo, they are trying to interrupt me from doing my cremation
No, if the
activities.
court says, no, what about the demarcation of that land? With that land is demarcated.
My lord, when I went for the survey, my lord, he interrupted me from performing this survey.
My contention is that they're trying to dispossess me in the guise of survey.
How is
They're
it possible, my lord?
interfering with my
If they are,
usage.
No, it is like this. In the light of the judgment and decree in an injunction suit, no, you're not in a position to say that this is what I want. Now, what is your suggestion and what is that you want so that their
Lord,
protection is also protected?
Admittedly, it is Kharab land. So the question of possession does not arise. My extent,
Their case is now, even that Karab land, whatever it is, now the boundaries are in dispute because you're also claiming some part of the Karab land. So how do we demarcate the Karab land now?
that is the entire suit, man. That is the entire suit.
There can't be any injunction now in that case.
So that's the reason, my lord.
No, it is not even your case that with respect to the other property of your, how much is the total extent? 5 acres.
6 acres.
6
4
acres.
So that's not even your case that they're interfering with your other part of the land.
They are. That's the case.
Hmm.
That's the difficulty, my lord. My entire
That is which
extent
is
is
adjacent to that Karab land.
adjoining, yes.
Yes. So now there can't be any injunction in those circumstances.
That's the reason this honorable court granted status quo.
How can there be a status quo?
No, my lord,
When a person who has lost a suit for injunction, can there be a status quo in an interlocutory application? When your main suit on the merits of it is already dismissed, how can there be a status quo? Can you be in a better position in an IA?
that
Please
suit-
come. Where is the order impugned?
My lord, at page
Page-
number 44,
Agree
my
with
lord.
orders passed in MA number 8 of 2019 dated 1st June 2019. The plaintiff is before this court. The plaintiff had filed the suit seeking declaration and injunction in respect of an extent of 6 acres,
4 guntas.
6 acres, 4
4
guntas.
guntas. 4 guntas.
6 acres, 4 guntas of land. It is his case that the defendants are interfering with his possession and enjoyment of the property. Where is the trial court's order?
It's in Kannada.
It's in Kannada.
Trial court by order dated 20th February 2019 had granted the injunction, interim injunction as prayed for. Agreed thereby, the defendant had filed MA number 8 of 2019, date 8 of 2019, and that appeal came to be allowed by order dated 1st June 2019, which is impugned before this court. While allowing the said MA, the court has observed that earlier in respect of the very same property, the petitioner plaintiff had filed OS number 218 of 2006 for the relief of permanent injunction. And the said suit was dismissed, holding that the plaintiffs are not proved boundaries of the suit scheduled property, and the said judgment was confirmed in RA number 89 of 2008. Further, the court also observed that the copy of the report of the surveyor produced by the fifth defendant reveals that the land which was sought for cremation of villagers is situated toward the southern side of survey number 90. Further, the copy of the Mahajar produced by the defendant reveals that 20 guntas of allowable land is situated toward the southern side of survey number 90, and boundary for the said 20 guntas of land is also shown as north by survey number 90 of Verehalli. Further, the sketch prepared by the surveyor reveals the fact of existence of 20 guntas of Karab land towards the southern side of survey number 90, and it belongs to Taraka channel, and the said land is claimed by the villagers of Ankantapura and Hari people and sought for his grant. Even that document also discloses that towards the northern side of 20 guntas of land, the land of survey number 90 is situated. Further, a certificate is issued by the Gram Panchayat of Hirehalli village, prima facie, reveals that the government Karab land measuring 20 guntas is situated towards southern side of survey number 90. And the said land, which is situated in between Taraka channel and survey number 90, has been used for cremation by the villagers. And the said 20 guntas does not belong to survey number 20. As such, the appellate court had reversed the order of the trial court and dismissed the application filed for interim injunction. A coordinate bench of this court on, well, again, is that the present writ petition is filed. A coordinate bench of this had granted status quo on 19/9/2019, and the said interim order has been extended from time to time. Land counsel appearing for the petitioner plaintiff submits that they've been enjoying the status quo order right from the year 2019. As such, and from the last 6 years, they've been enjoying the status quo order granted by the court. As such, the same may be made absolute, and a direction may be granted to the trial court to proceed with the matter. He submits that the petition is a owner of the property. The injunction, the judgment that's passed in injunction suit has no bearing in the present suit, which is a comprehensive suit for declaration. He submits that the villagers under the guise of the said Karab land are trying to are interfering with his land, which made him to file the present suit.
One submission. Lord, in my schedule, Kharab land is not included. And that observation has been made. But it says, it is very clear from the said document, the land measuring 6 acres, 4 guntas, no burial ground is existing. Which they are also not disputed.
No,
I am disputing it. Towards the southern side of the channel, my lord, in the plain sheet.
it is submitted by the land council that in the 6 acres, 4 guntas of land, there is no Karab land, and the Karab land is adjacent to the adjoining the land of the petitioner, and under the guise of the said Karab land, they're interfering with his
It's also observed in the
with his land. Next para. Land council appearing for the respondent defendant submits that, and the guise of the status quo order. This status quo, because of the status quo order, the entire villages are put to a lot of hardship. It is submitted that they've been using the land for the cremation purpose. It is submitted that the appellate court had rightly set aside the order of the trial court when the suit for injunction filed by him in respect of the very same land and very same defendants has been dismissed, and when it has attained finality, when the appellate court has confirmed the order of the trial court, he submits that continuing the status quo order is not will cause a lot of prejudice to the defendant, and the petitioner is not entitled for such a relief from this court. Next, having heard the counsels on either side, there is a material on record. There is no dispute about the fact that in respect of the very same property and against the very same defendant, he has filed a suit for the plaintiff had filed a suit for injunction, which came to be dismissed. And against that an RA is filed and RA is also dismissed. Hence an order passed in the injunction suit has attained finality. There, the court has also observed in the injunction suit that the boundaries of the petitioner property are not clear. Then as such, injunction was not granted. Now in the suit for declaration, the idea that is filed with the petitioner plaintiff is also in the similar grounds, in the similar lines. The trial court, without considering the said fact, had granted injunction. And in the considered opinion of this court, the appellate court had rightly considered these issues, the issue of granting injunction in favor of the suit of the injunction suit that is dismissed. And the appeal that is in the appeal which has attained finality and rightly held that the appellant is not, the petitioner is not entitled for injunction. And this court finds no reasons to interfere with the well-considered order passed in MA number so-and-so. Accordingly, the appeal is, the writ petition is dismissed.
Cell number
Much
3.
obliged.
S. Hemant Bharadwaj for petitioner, Kapil Dikshit for respondent.
For the petitioner mother in the other case.
My lords, those, my lords, those Nimhan's sessions have taken place. Report
What
may,
has happened? Any report is placed?
the report may be placed with the court because my lords, as per the
They
order.
have not been given copies.
As per the order, 10th, they were supposed to,
Report.
as per my lord's last order,
Email copy of Nima's report dated is placed below 10/3/25.
could my lords give us a copy so that we can review, in
Let me
fact,
just look at it.
very well.
What the recommendation is, Arohu's mother and father would benefit from sessions with the psychiatric social work team, Department of Child and Adolescent Secretary for discussion of co-parenting plan. These sessions would be conducted in the Child and Adolescent Secretary OPD on Mondays and Thursdays. Further evaluation of the child needs to be done on outpatient basis over 6 to 8 sessions with the child on Monday, Thursday in the Child and Adolescent Secretary. That's what is there.
In fact, on the last session, I was told they had a session with the parents. Initially, the sessions were only with the child. And to the extent that a social worker be, I think what my lord said, to some extent, I think the doctor informed the parents, but the rest of the report we've not seen.
No, will be.
Yes.
We'll ask them to furnish
Yes.
a copy of it
Yes.
also.
May
I
I
think let as per the recommendation, let it go on.
let it go on? In fact, I only wanted to say whenever we can see the report and if my lords want to fix a date for arguments, or maybe after this also, that is fine. I think some 7 or 8 sessions they've recommended.
After that, you can submit,
Very
make
well.
your
In
arguments
fact,
basing on the report.
yes, and the same visitations can go on. In fact, they asked the parents, I mean, they asked the mother what she's doing. With regard to the child, she did mention that she's going to another counselor, but if they suggest here, she has no difficulty to continue on an outpatient basis.
That's what they said.
Which they have said. I'll just confirm whatever they said.
Your Lordship.
Mondays or Thursdays, she'll see it. So that that should be after school. Yeah, except. No, whatever it is, if there is some logistical issue, they can work it out if she has some exams, I think. But I think after the exam should be over now, there should be vacations. So I think that should be fine. That should be fine. If my lords gives us the copy, she'll know what days they have recommended. We can do that. There's
Your
no
Lordship,
difficulty.
no, they didn't say anything because, it's just waste of time. Again, another, nothing, what they said was, it is only on OPD on Mondays and Thursdays, and she required that for 6 to 8 sessions. That's it.
That's fine. No, we have no difficulty. If there is a specific time for OPD, she will just check that it is not
So then that
interfering with
will
her
pass an
exams.
order, also considering the child's school and other things.
Yes, that's
Let
all.
them give a date. Anyhow, it won't be in the evening or the night, how it is feasible to the child.
Your
Because
Lordship.
the doctors have to work. its
Yes,
time
doctor.
frame.
Only thing is it should not
Your
come in the way of her exams.
My time.
There are
My
exams
time.
that can be
Okay, just
accomplished.
for all of this, yes, Your Lordship, it has to go on, might go on. I have filed an application for change in custody until such time that Your Lordship decides. Reason being, one is the orders passed by the lower court wherein shared custody was granted, but I was granted from morning to evening at her residence. We wanted it slightly modified because all along both were co-parenting in half-half completely, where he was taking care of the child from when the child was few months old up to 2023. Suddenly it changed. We came before this, Your Lordship, for change in that wherein I needn't be in her house all the time. During this period, she conveniently shifted her residence where we were both opposite to each other. After that, Your Lordship has the detailed orders that Your Lordship has passed. One was to overcome the order in the lower court where in the morning she filed an objection, evening she filed POXO case, where none of those details were mentioned in the morning, but evening suddenly POXO arises. That order, that entire matter FIR has been quashed. Reasoning in that also is clearly stated that it is to overcome certain things here. Your Lordship has also passed very detailed orders where the child was asked by Your Lordship felt that the child was saying things only because she was worried that the custody of the mother would be taken away, all of that. Now, every time we have an order, it is being watered down so badly that now in the presence of strangers, he has to be with his child when it is clearly held that there is no POXO case. Now, what happens is that every time the mother seems to get away with false cases being filed, and I would request Your Lordship to finally lay down the law in this matter, which could be followed in all other matters, which would act as a deterrent, where the ladies are not allowed to file such heinous crimes and make it seem so frivolous just to overcome some order by this court. And it's very, very cruel on the part of the mother to do this to the father. Now, Your Lordship even mentioned that suo moto, there should be some kind of contempt filed as against her. That again was not recorded in the next date of hearing. Contempt did not come to be initiated. Now, she was to ensure that the child, whatever orders that Your Lordship passed in enhance, that was not being followed. Twice, there was complete disobedience of Your Lordship's order. Then she comes and says, the child is not comfortable, I won't do it. Then she goes and finds her own counselor, a private one in a private hospital. Now that person's not even a psychiatrist, it's a psychologist. That is also being accepted by this honorable court, which means they have scant regard for Your Lordship's orders. We will do what we want, and that has to be followed. Your Lordship, that cannot be ordered because we have to have some respect for this honorable court's orders. Your Lordship, contempt is not, she overcomes, she is able to find such a heinous crime and then get away with it. Your lordship, if she's filed something as cruel as POXO against the husband and that's been
No,
quashed,
if there is a malafide.
intention is there. So
you
your
have
lordship,
remedy.
all I'm
That, in
asking
fact,
is,
he has
no, no,
already
no. Can I
commenced that
finish?
remedy.
I didn't interrupt.
No, he
All
has
I'm
already
saying is that
commenced that remedy.
I have come with an order from the lower court where I had 3 days in a week, whole day with the child, and that has been overcome. And all the orders have been watered down, where now even the ink cannot be traced. Your lordship, all I ask is I filed an application, let them file objections. Matter could be heard in finality. Meanwhile, all these, what is happening in Enhance is very good for all of them. Let the parents also take part as they have suggested. Let those reports come in gradually. But meanwhile, this cannot be used.
No. Please understand. When the girl is saying something like, when everybody is around, she says that my father is doing that and this. Do you think that the girl's state of mind is normal?
No,
You
no,
want,
yes,
you want a healthy, you want
You want a healthy
your
child.
welfare of your child, or you want custody at any cost?
No. The child, your lordship, ultimately is being tutored. So who needs the treatment? It's the mother that needs the treatment.
My
The child
lords
is
are
ultimately following what the mother says.
last several
Now,
hearings, my
1
friend
minute.
has not been
No,
there.
1 minute. Then they file an affidavit, which they just served as a copy. Details of what transpires in each hearing. What they're saying is, child came in, the child came off outside without, even though they tried to talk, she refused to talk. Even I asked what happened, she refused to be there, she came. Now, all of this is stage managed and we know, we are all aware of it. I understand your lordship wants a good frame of mind for the child and we would also want it. That's why this should continue. But the person who deserves it the most is getting away scot-free, your lordship. Let her be directed that if she can go around to such depths to ensure that the father doesn't get the child, then she's the one who needs evaluation. Yes, the child definitely needs a better environment to be told what is to be done. That we want to continue. Absolutely no. But if your lordship's orders are disregarded, then I'm not acceptable, your lordship. When your lordship has made so many observations, I just went through all of that. But conveniently everything, how does she decide to go to a private psychiatrist, your lordship? Your lordship had said enhance. And your lordship had said they should be inpatient. None of that is being followed, your lordship. If your lordship kindly goes back to the earlier orders and asks them why are these not being followed, they don't get to decide or dictate terms to this honorable court. And now they file affidavit. I have filed an application that till such time all of this happens, shift in custody automatically.
Give the custody to whom?
To the father. And your lordship, there would be a complete
basis?
change.
On what basis the custody?
Yes.
should
On the
be-
what
should be
basis,
shifted
since
to
there's
the-
already a complete hearing by the lower court also stating how comfortable the child is. Now to overcome all these orders, now suddenly all of this is happening. Your lordship has also observed what the child stated.
No,
Now,
whatever you're saying about the mother,
please.
As well true, as at the same time, all is not well with the father also.
Your lordship might kindly say where we need to
He's
correct. We'll
never-
correct
he
ourselves
never-
immediately.
He never understands how to deal with a situation like this. All the time, what he wants is, even the videos and all. You might have
Videos, he's
seen.
trying to hug the
He's just the
child,
way-
are trying.
Is that the way a father deal with a child who is already in a different state of mind? So it is not about the fighting for the custody. Now, once an enhance plays a report before this court, then neither know why this court has not taken a stringent action against the mother is the reason. As an inpatient, keeping a child there for so many days and under the circumstances, I'm told like they're not maintaining even I
hygienic
spoke
way.
with the
Right.
director Nimhans also. That's why like.
No, we don't want the child there. I'm
but your
talking about the
client-
mother,
no,
your
that's
lordship.
what your client wants. He was saying that let her be there, let her be there.
No.
That's not right.
No.
He is not fighting it is not about fighting for the child, not fighting the wife under the guise of this. No. Ultimately the welfare of the child is more
It's of
important.
paramount importance.
If you look
yes.
at the girl, if they look at the girl, she's definitely not normal. First of all, that has to be answered.
Your lordship, then who would be responsible? Because it's not
That
under
we
the
will see, that
guidance
we
of the
will see.
father that she's not normal.
No. If given an opportunity, the girl, let the doctors interact with her, find out that these are all the reasons for this. Then we will take an action.
And if
We
they've
cannot
advised
assume and
this-
presume
Your lordship,
who is
your
responsible for
lordship
that.
already noticed her behavior. Lordship
this
has
is-
noticed the pattern as to what extent she could go to. Then wouldn't it be correct, your lordship,
No,
in other
ultimately
matters,
all
it's
said
body
and done.
evaluation.
all said and done, while exercising the parent patriae jurisdiction, the ultimate this thing of the court is the welfare of the minor.
please.
So first, let us first
Let us address
ensure that
Let us
the
address
minor
that.
is mentally and physically, by all means, what is her state of mind and what is required in her interest.
Could I
So
request
that
that
is-
parallelly, we are also put, your lordship is saying even the fathers or, so why,
It
parallelly
is
if
the
the
other
parents
way, if it is
also.
the allegations and the, things are like in a normal phase, definitely court would have said, let us experiment on that, but
Correct.
not under these
No, no.
circumstances.
And in,
Request, all I'm saying is, since the child's also undergoing, if the mother's also put through it, there's nothing
No,
wrong
what
with
is
that, your
this? You
lordship, because your
don't
lordship
subject
has
me
noticed, your
to-
lordship's not
I'm
disagreeing on
sorry.
that aspect.
he wants to undergo,
No,
he
no,
can
no,
undergo
no.
any counseling.
Your lordship.
He's free to undergo any counseling.
Your lordship, all we are stating is.
No,
that-
they're also interacting with the parents. Doctors are not, if they find that something is not well with any of them, that will also.
In
be brought
fact,
before-
Lordship,
prior
there
to the
could be a-
last, I
if
want
there
to
could
just
be
make
a
a
fine-
submit.
If there could be a report which the NIMHANS is submitting based on what is the influence of the parents on the child also, that would also be helpful, your lordship. Please.
NIMHANS knows what report to submit. We are not here to dictate. In fact, prior to the last session, both parents were called. Prior to that, when the doctors were interacting with the child, the father kept writing to the doctor saying, I want to meet you, I want to meet you, I want to say things. The doctors did not entertain that and only called the parents whenever they felt.
I
it
think in
was-
all these matters,
Yes.
in all these problem of child custody and all, the parents should be sent for counseling. I
Yes,
think that
yes,
should be the
yes.
best.
Let them both parents be sent.
Both I'm
Both
saying.
parents,
I didn't
because
say
Not,
allegations
it's
are
not
made.
about one. Both of
Allegations
them
are
are
made.
not, both of them were not all right. If they're all right, things would have settled much.
Therefore,
long back.
allegations cannot be just made on one side that this is
No,
happening.
where
that
is the court
happening.
saying that?
No, not the court, not the court. I'm
That's-
talking about.
No,
authorities
the
the
court
bar,
is
not
referring
the
to
court.
both the parents. First
Not
of
the
all, they
court.
should be psychologically and by all means, they should be fit to take care of all these things.
No,
I think let the doctors conduct the counseling for both of them
Yes,
also.
please, please,
Let- Let the.
Because anyhow, they're going to, they're
No,
going to.
ultimately, the doctors, whatever they recommend, my lords asked us the last time, my friend has not been here on the last 2-3 hearings. This honorable court asked, let them go for 4 weeks.
Because that's
We
the
have done
practice,
that.
no, that the
Yes,
practice in
no,
all
no.
these matrimonial and this child custody matters, every senior counsel on every occasion.
No. In fact, it breaks the continuity because my lords have stated some things have happened in the last few hearings. These 4 weeks were done. Now, based on the report, whatever else is advised, as my lord
Doesn't
said, we
break
will
any
continue.
continuity, it breaks the watered down orders, and that is what
That
they
is
have
for
a
the court
problem
to
with at this
protect.
point of
That
time.
is for
I
the
have
court.
seen
They are
all
in
the
my
orders,
lord's, hands.
exceptionally good orders that have been recorded, which they somehow find a way to get away with. And that is what their problem.
Are they
today is
alleging
what
that
I
the
am
court
bringing
is
out.
helpless?
No,
Are
no,
they
no.
alleging that the court is helpless? We are in the hands of
No,
this
we
honorable
understand
court.
what she is attempting to do at this point of time. Your lordship always says, let the parents also
No,
submit
whatever
themselves.
both of you attempt to do, but I'll understand the facts as it is.
Of
Please,
course.
your lordship,
Yes,
all
my
we are
lord.
asking is let the parents also be
Come,
put to.
please come. I'll ask them to give a report to both
Copy
the
of it.
parties.
Yes.
Please. And both the parents also.
And
if they-
my lords,
Yes.
can I just, may I just, my lords?
In that I'll not order any notice or objections.
No, that's fine. And may I just an affidavit of all the visitations. I've served them a copy. Can,
File it in the registry.
I'll
Anyone
file
who's
it.
going to look at it now.
no,
As per the
urgency.
earlier order passed by the court. Order dated 4/2/2025. A report is placed before the court by the director NIMHANS. The report reads as it is completely pasted. As per the recommendations, the NIMHANS has made the recommendation that 1 and 2 again. As per the above recommendation, the child shall undergo the 6 to 8 sessions, that is on Mondays and Thursdays, as fixed by the NIMHANS. NIMHANS, while fixing the sessions, shall also take into consideration the exams or other activity exams of the, exams of the child. And accordingly fix the sessions. Next, for the both, while giving, while the girl is undergoing the sessions, the NIMHANS should also assess the influence of both the father and the mother on the child. And both of them shall also be counseled simultaneously. And a report shall be placed before the court after the sessions are completed. Registry is directed to give a copy of this report to both the councils. List this matter after the report is received from the NIMHANS.
Would my lord set a date?
Till such time his visitation.
The same visitation.
He
Same.
will be meeting there. He'll be meeting and interacting there.
Yes, the
Every
same
time he's
visitation
present,
as
he'll be
last
there in
date.
the NIMHANS. On every
This-
session of the girl, the father will also be present in NIMHANS, in the session.
Besides that, any other
Uh-huh.
time, your lordship, besides that, some other time with the child, your lordship.
No, anyway, Mondays,
Monday,
Thursdays is
right.
there.
No, it's happening on Monday and Thursday. 2
Monday
days
the-
he'll be having.
On
Yes.
weekends sometime, without the
No.
influence of that environment itself is different, mall or something like that, your lordship.
No,
For
my
some
lords,
time
this was,
Yes, let him have the patience for another 1-2 months. And then the court will, once the report is before the court understands what it is. Then with all this, the presence of a third party and all, we'll pass some order. Right from the beginning, that's what I was telling him, whenever he was present before the court also. Even when the daughter is saying that he did something to her in the presence of so many people, still he wants it at home.
No, not at home with the boy.
No, I'm saying, let's just give it a break. Give it a break. No, it's not going to have any, no, it's good for him. The more patience we have in these circumstances, it will help him. It is not about, like, it's fighting against his wife, or the wife is getting over the orders of the court. Court is conscious of what is going on. Ultimately, in the interest of the girl, the orders will be passed.
It is the longer the alienation, the longer the
No,
distance
every day
is
he'll
created,
be,
that's
no,
all.
what will happen, no, like once a girl starts feeling that, in a compulsion she is made to
Correct.
go to the father, then it'll have an adverse effect and she starts, having this, those feelings against the father. So why to invite it? Let her see, first of all, mentally, let her be out of all this. Then she'll be able to consciously take be happy with what's going on. And what is required, then we will take a call.
would my lords give any date or await would my lords give any next
No,
date?
the moment the report is, the sessions are over, the report is
It
placed
is.
before the court, the matter will be listed.
Very great.
Yes, yes.
1 month, your lordship.
Huh?
1 month.
They said it.
I think they said 6 to 8 sessions.
One report in between instead of waiting for the entire.
No, let them finish the sessions because they have,
For them will be longer. In between at least.
no,
one
they
more
have,
week.
they have requested for whatever time, let them finish the session, submit the
We'll see
report.
after that.
And-
Yes, next.
Then number 4.
So that the registry.
I am for the respondent, my lord.
4, Satish.
I am for the
Why you are
respondent.
not there? How many times the matter has to come in the list? Yesterday I was about to dismiss it for default. Huh?
It was posted on the previous occasion.
Uh.
I represented the case, where in first instance, the case was passed over, and the second instance, I made a submission.
Yesterday also you were not there. When it has come 2 times, yesterday I wanted to dismiss it for default, but again I have adjourned the matter.
Since on the previous occasion, I made a submission that the advocate on record, Satish, as I entrusted the case to him, so the list was not coming to him, the list was going to Satish. I'll get a proper NOC from him and file a proper wakalat, because this is happening due to the miscommunication between the council on record and
No, you have to file an objection, wakalat.
by next date, I'll do that. I'm deeply sorry for the.
What is your name?
M. Subramanian.
It is submitted that. Yes, recently has received a no objection wakalat. And he'll be filing the wakalat within a week in the name of him also for the petitioner. Yes. Print his name for the petitioner. Yes.
Delete from caption.
Next.
Cell number 5. Shiva Reddy, KN. Cell number 5, Shiva Reddy, KN for appellant.
Appearing for respondent 1 mile.
Mesh Kumar RV.
They have furnished with me with the LL copy, my lord, stating, my lord, the claim petition was, insurance company was exonerated on the premise that as on the date of the accident, he did not possess a DL. It appears after a month or so, he has obtained it. He has given me a copy of the LLR. I have sent it to the company. If we verify means, then I think we will accept liability, some short date.
That the copy of the driving license is.
Learner's license is.
Learner's driving license is, it is submitted with the learn counsel appearing for the insurance company that the petitioner has furnished a learner's license to him and the same is sent for verification. It requires how much time?
About 10 days, please, ma'am.
10 days time. Does this matter after 10 days? Delete from the caption for dismissal. Give a date.
2 weeks.
Depending on the matters, they'll give the date or 10 days. Yes.
26th or so. 26th.
26.
Obliged, please.
Yes, next matter.
Serial number for order, serial number 6. AM Venkatesh.
Translated copy, sir. Right, office with the copy, 25/10/2024.
You filed already.
I ordered it.
And counsel for the MFA of 2012 and counsel for the appellant submits that they've already filed a translated copy of the appeal, the judgment. Is this matter day after tomorrow along with that?
Not tomorrow, madam. Monday.
Day after tomorrow.
Monday.
Monday.
Day after tomorrow.
Yes.
Monday. Serial number 7. R. Jay Prakash for appellant. Spurti Hegde.
Respondent, my lords.
Morning is.
No
outside.
representation for dismissal on Friday. Yes, next.
Serial number 8.
My lord, I am for appellant. My lord, in this case, my lord, the short question before your lordship is apart from quantum. My lord, 30% negligence is foisted on the claimant. My lord, facts of the case which is narrated in the judgment, it may.
What is this non-filing of translated copy? What copies are required?
That's why I'm trying to convince my lord regarding that translation copy may not necessary because my lord, the manner of
In every case, it's why this.
the manner of main.
Why every document is required? No, it is only when you ask it will be. No, it won't be like that. Who appears? Yes, Mr. Mahesh, you are ready?
If he is ready, I am ready.
Yes.
May I
So
submit, my lord?
First is you are asking for, you are seeking enhancement.
My lord, first one enhancement, second part is negligence, my lord. My lord, the facts of the case is, my lord, the appellant was proceeding in his motorcycle and the vehicle belonged to respond auto rickshaw came and dashed. The police document, all other documents clearly shows, my lord, these auto rickshaw dashed to the petitioner's motorcycle. My lord, in the first instance, while admitting the hospital, my lord, immediately after the accident, there is one sentence is forthcoming in the medical record to the effect that when he was overtaking another motorcycle, my lord, this lorry came, this auto rickshaw came and dashed. My lord, the FIR is lodged by another rider of the motorcycle. This auto rickshaw also dashed to that motorcycle also. My lord, only on that count, without having any rebuttal evidence, my lord, only insurance company came with this history of this accident. And without appreciating the same, my lord, tribunal jumped to the conclusion that there is a 30% negligence on the part of the rider of the motorcycle because because only on one count that medical record shows he was overtaking the vehicle and this auto came and rash and in a rash and negligent manner and dashed to the motorcycle of the claimant. Only on that count. My lord, that medical records is also produced by the respondent
Please
insurance
come to the
company.
order. First come to the order and come to the
Yes,
finding.
my
Then
lord.
we'll go to the documents.
My lord, issue number 1, my lord. Issue
Yes.
number 1 starts from page number 7.
Yes.
At the time of evidence, the petitioner himself, para number 7, my lord, examined as PW1 and on his behalf 2 witnesses named Sunil
No, where
Kumar
are we
GB
going to
working.
pay? No. Please come to para number 14.
40.
Para number 14.
As per Exhibit P1, copy of the FIR and complaint one of the injured person by name Ramesh, who is a rider of another motorcycle bearing number so and so, has lodged the complaint to the concerned police immediately after the said accident on the same day at about 10 p.m. As per the averments of the complaint, on the above said date, time and place, when the complainant was riding his motorcycle, the driver of the app auto bearing number so and so drove the same in rash and negligent manner and dashed against the motorcycle bearing number so and so K05HK. That is the ride petitioner motorcycle. And thereafter auto against the complainant's motorcycle, and thereby he and the rider of the above said motorcycle has sustained injuries. Exhibit P2, copy of the spot pancham shows the complaint has shown the place of accident to the police and pancham and the police have drawn the said Maja in the place of accident on so and so date. Exhibit P3, copy of IME report shows that the concerned IME inspector has inspected the above said 3 vehicles and he has noted the damage caused to the vehicle bearing number K42, K5, HK, but no visible damage found on the vehicle bearing registration number K05ER 5336. According to the opinion of the said accident was not caused due to a mechanical defect of the said vehicle. Exhibit P4, copy of the wound certificate is belonging to one Ramesh, complainant. As per the document, the complaint took treatment at government hospital on so and so date, caused injuries, road traffic. Exhibit P6, copy of the charge sheet. This is important. Exhibit P6, copy of the charge sheet shows that pertaining to this accident, after completion of investigation, the concerned police have submitted the charge sheet against the driver of app auto bearing the registration number so and so. Exhibit P5, discharge summary of Sairam Hospital of the in the column history. It has been mentioned alleged history of RTA in Harovali Kanakpura main road at 6 p.m. collision between the two-wheeler and auto. But the in the statement of response number 1 has mainly contended that the accident took place due to the negligence on the part of the petitioner himself. But while riding the motorcycle and in the process of overtaking a vehicle which was going ahead of it, came to the extreme right side of the road and collided with the auto which was coming in opposite direction and caused the accident. And as such accident in question occurred due to negligence on the part of the petitioner himself. In the oral evidence of RW1, he has RW1 is the insurance company officer, Melon. He's not eyewitness. Reiterated the same. It is seen from the record that the cross of RW1, the learned counsel for the respond number 1 confronted the copy of MLC extract of PW1 and put a question that
What are the injuries sustained by you?
well,
in the
severe head injury and comminuted fracture of clavicle, fracture of bilateral temporal bones.
Who has taken the claimant to the hospital?
That is not forthcoming. Mostly another rider. The main question is, Melad, merely because a statement is forthcoming in the medical record that he was while overtaking another vehicle in a rash and negligent manner, the respond vehicle came and dashed. Only on relying upon that he is overtaking.
Why would the hospital authorities record such a statement unless and until it is given by the concerned?
Somebody else, my lord, because he is not in a position, he is totally
What
unconscious.
steps you have taken? What steps you have taken?
What steps
the claimant has taken?
Melad?
What steps the claimant has taken?
my lord, he is admitted the hospital in the unconscious stage and produced all the medical records. Medical record which shows, my lord, severe
No,
head injury.
you're relying on the medical records. For all
Medical
the
record.
injuries and everything, for all the
Well,
injuries and everything. Why not this one exhibit so and so?
My lord, these are proved in accordance with law because the doctor came before the court and given the evidence regarding the injury sustained. My lord, these are only because, my lord, there is a stray sentence available in the medical records. Without they come with an contention that there is a contributory negligence. To prove the contributory negligence, my lord, there is something is to be proved. But 30% negligence only relying upon that medical history, my lord, according to me, my lord, it is not supported by any legal acceptable evidence, my lord.
Yes.
That
Now
is
come to the enhancement that I understood. And enhancement.
only on that. My lord, pain and suffering.
Come to that. Where is that?
Quantum, my lord, page number 19, para number 20.
Where
Sorry,
is the
quantum
table?
90.
Table.
Mostly. Table found in page number 29. My lord, out of 4,26,000, 1,84,770 is the medical bills. My lord, the long period of hospitalization. My lord, the injury found in page number 20, my lord. Page number 20. Well, the disability also may kindly be considered because he lost the total hearing loss, my lord, and vision is also blurred. There is a mal, my lord. This 29 years boy, my lord, now suffering from 42% limb disability resulted in 14% whole body disability, my lord. PW3's evidence, doctor evidence is relevant as far as injury and
How many days you was in hospital?
42 days, 10 days first instance, 42 days in second occasion. First is Sai Rama Hospital for 10 days, Ambedkar Hospital for 42 days.
Which year is the accident?
2011.
What is your income according to you? Occupation?
My lord, I am agricultural, also doing petty business. But I said 12,000 is my income.
Accident is on?
2000, that is 14/6/2011. PW3 is the doctor, Milan. He deposed regarding the injury sustained, as well as now what is the condition of the appellant.
Injury is head injury, laceration or right knee and partial tear of right of multiple bilateral temporal lobes and norma, right clavicle comminuted fracture. What is the future medical expense that is required?
My lord, 25,000, as per the doctor, my lord, to remove the implants, my lord, he required some 25,000 as per the evidence of the doctor, my lord. Page number, para number 8 of the doctor's evidence, my lord, PW3.
Medical expenses, any dispute on that?
1,75,551 is the medical bills produced, my lord. In addition to that, 10,000 is also given. But my lord, incidental 52 days, my lord, it may require some enhancement, my lord.
Come to that future earning capacity, which para? Come to the disability.
Yes, my lord. That is a forthcoming in a page number page number 27, top of the this line, computation is made. 6,750 into 12 into 16 into 10.
No,
10%.
where is the doctor's evidence with regard to the disability? That I am asking.
Yes.
Come to paragraph 25.
At the time of evidence, the petitioner has got examined PW3 Dr. B.S. Venkatesh, orthopedic surgeon of Sairam Hospital, Bangalore. In the examination chief, evidence affidavit, PW3 has stated that with respect to the injury sustained by the petitioner in the road traffic accident which occurred on so-and-so date and the producer and the procedures underwent in their hospital for the fractures, injuries, and he has stated that patient discharged on 25/6/2011 with the advice to undergo regular dressing and to continue antibiotics further. He has stated that on verification of the record, the patient admitted twice at Dr. Ambedkar Medical College Hospital, Bangalore for facial nerve decompression due to the left facial nerve palsy for excision of keloid over neck and flap repair under general anesthesia. He has mentioned the complaint of the petitioner as noted in the affidavit, and he has mentioned the disability found in clinical and radiological examination of PW3 has opined that patient suffers from permanent residual disability of about 42% to the part and 14% whole body disability. He has identified the disability assessment copy, case sheet, X-ray, and the same was marked as so and so.
Court has taken the disability as?
As a 10%.
As per the doctor, it is 14%.
14%. Well, as I noticed, my lord, actually, neurological this deficiency is not proved, even though he is suffering from severe head injury and consequential this one disability. Only orthopedic surgeon has been examined. It may be a lapse on the part of the claimant, not to examine the other doctor. That is why, my lord, as far as functional disability is concerned, I am requesting my lord to consider it in higher rate.
What is the multiplier?
Multiplier is 16, 29 years. Well, 4,500 is considered and future prospect is added. Well, it comes to 6,750 per month.
Future prospects, how much it is considered for a
Plus
disability of
50%, 4,500 plus 50%, that is 2,250.
No, 10% disability, for that 50% future prospects are considered.
Yes, future income.
That I saw, that we can't give.
Future medical expense 25,000 is awarded, my lord. My lord, my main appeal, main contention is regarding the these contributory negligence to an extent of 30%. 30% only by relying upon this one entry without having any rebuttal evidence. My lord, it is not permissible. It is my first contention. My lord, second contention is regarding the quantum, my lord. My lord, may kindly notice another thing, my lord. FIR is given not by claimant, my lord, because he sustained severe head injury in an unconscious stage. Another rider of the motorcycle, he also sustained injury. He given the complaint, and in the complaint, my lord, no such this content, this sentence and these facts are not forthcoming in the FIR. Immediately, it is given by another rider who also sustained injury. My lord, who has given that history is not forthcoming, my lord. And it is this document is produced by the respondent insurance company, not from the custody of the hospital.
Yes, Mr. Mahesh.
Yes,
What do you say on the contributory negligence?
yes. Now I invite your lordship attention to my lord, type at page 12 of the judgment.
Yes.
Exhibit R1, my lord, with reference to R1.
Yes.
Exhibit R1, copy of the medico-legal register issued by the medical officer of Sri Sai Ram Hospital, Bangalore. It is seen that as per this document, the petitioner admitted to the said hospital for treatment on 14/6/2011 at 7:30 p.m. With regard to the cause of the injury, it is shown as under alleged history of accident RTA near Haravali, so main road around 6 p.m. Collision between the two-wheeler and an auto. Two-wheeler was overtaking a vehicle.
Yes.
Malad, this is the first document which has come into force, Malad, at an undisputed point of time.
Yes.
The complaint, Malad, and the investigation, Malad, it will be later. There will be a chance of improving or concocting this thing.
Who was examined in support of that document?
Yes. Then, Malad, in coupled with that, IME report may kindly be looked into, Malad, exhibit P3. That clearly shows that he was trying to overtake another vehicle and went and dashed against the auto which was coming from the opposite direction. Actually, Malad, it should have been 50-50, but the court has held 30%. We are not prepared any appeal. Therefore, Malad, it does not require any.
That is exhibit? IME report.
IME report exhibit P3, Malad.
Yes, what do you say about exhibit P3, Mr. Shastri?
Malad, comparatively, Malad, it is an auto rickshaw, big vehicle. Just if this vehicle touch to the tire, front wheel, Malad, definitely these auto rickshaw may not get any mark or anything. But thing is, Malad,
what is the report I'm asking? What is the report? You didn't argue on that. What is the report of the
IME report, Malad? IME report says, Malad, no visible damage to the auto rickshaw. That is the IME report, Malad. Just I want to.
No, Mr. No, what he was saying is that while overtaking this has happened, something he's saying now.
No, it is dashed, my lord. That is the vehicle dashed to the, this auto rickshaw dashed to the motorcycle is not in dispute. But only thing is, my lord, this the spot of accident. That is according to insurance company, my lord, because there is an entry in the medical records, my lord, who has given it, that is not forthcoming. But according to this entry, my lord, while this petitioner, while riding his motorcycle, in a process of overtaking another motorcycle, another vehicle, my lord, he came to the right side. That is the contention of the insurance
Then
company. my
that is, then both the reports are in consonance with the other IMV report and the medical report. It is not alone about the medical
IME report does not, IME report does not says anything. It is only,
That IMV report.
my lord, K423982. My lord, that is three vehicles involved, my lord. The auto rickshaw is K05HK2990. K for 423982. 3982. 3982. My lord, front right head right is damaged. That is the report, IME report. Front right head.
Mr. Mahesh?
Yes.
Mr. O. Mahesh.
Sir.
Yes, ma'am.
Mahesh, sir.
Please
Yes.
refer to this motor vehicle accident MV report.
Right, what I am trying to canvass before your lordship is that
Hmm.
if my lord auto rickshaw has dashed against the my lord the motorcycle, head-on collision, then my lord nature of my lord the damages caused on each vehicle involved said to be involved in the accident would be different. My lord, what I am saying is, in the light of exhibit R1, he was trying to overtake another vehicle and went and dashed against the auto rickshaw coming from the opposite direction. That corroborates, my lord, that. And PW1, my lord, was driving, my lord, riding the motorcycle without a driving license. It has been an admitted fact in the cross-examination of PW1.
Yes.
Yes.
Then please
My
come
lord,
to the.
That is, my lord, it's in 1 minute. That shows, my lord, he was riding the motorcycle contrary to the law and also overtake the vehicle without considering the, my lord, the vehicle coming from the opposite direction.
Yes.
So therefore, according to us, my lord, it should have been 50-50, but 30% is this thing, my lord, and we are not preferred any appeal. I am only, my lord, your lordship consideration that 30% contributory negligence does not require to be, my lord, because it should have been 50. Then coming to, my lord, the issue of, my lord, the quantum. You want to kindly turn to, my lord, evidence.
Come to internal page 29.
21, my lord, paragraph 25. Yes. My lord, para 22, doctor refers to, my lord, exhibit P18 to P20. But in the cross-examination, PW3 has stated that now the patient is walking without any external support. That is important. Further, he has stated that for the clavicle fracture, he has not mentioned the disability. Only for the shoulder joint, he mentioned the disability. There is no fracture to the shoulder joint. Even though PW3 has opined that the patient suffers from permanent residual disability of about 42% to part of 14% to the whole body. But before giving such opinion, he has not mentioned in the affidavit as to how he calculated such percentage of disability caused to the patient and which guidelines he followed while assessing the disability. As I have already stated, in the cross-examination of PW3, he has stated that now the patient is walking without any external support. Therefore, on consideration of the above facts and circumstances of the case, and in view of the evidence stated PW3 in the cross-examination, for the reasons as stated supra, the permanent disability caused to the petitioner can safely be fixed at 10% to the whole body. In fact, 14% as stated by PW3 in his evidence. That is, my lord, the so far as. Then here you also kindly read. He is said to be, my lord, an agriculturist. He has not produced anything to show or material how this alleged disability has reduced his earning capacity. He is aged about, my lord, 30 years, and this disability will not continue or reduce his earning capacity as an agriculturist. Therefore, my lord, there is no evidence either by my lord PW3 or PW1 that his earning capacity is reduced because of this disability. 14% disability, my lord, is not at all like a disability. Even if a normal person, my lord, is examined, as per the formula, my lord, the normal person will have 15 to 20% disability. And more than that, my lord, it has to be, my lord, document has to be produced and evidence has to be laid in, even if that alleged disability, how it has reduced in future. That is not there. It is only entitled for loss of amenities of life, not for, my lord, the future loss of earning capacity, which has not been proved.
Yes.
Therefore, my lord, my respectful submission.
Yes.
That, my lord, the award made by the tribunal, considering, my lord, both the on point of negligence and also the, my lord, and PW3 doctor has admitted, my lord, that he is walking without support.
Yes. Please come.
And he has not mentioned, my lord, anything about, my lord, the fracture in the disease, how he has arrived at 14% disability to the whole body.
Yes.
And calculation is also not forthcoming. Therefore, my lord, my respectful submission is that, and PW1 has admitted, my lord, that driving license, my lord, he was not having a driving license, it has been lost. That is a ruse, my lord, to show that he was riding the motorcycle without the license, contrary to the provisions of the Motor Vehicles Act, and causing inconvenience to the public to use the public road. And Exhibit R1 clearly established, my lord, that he was overtaking another vehicle and it has been, my lord, because of his negligence, accident has occurred. In support of that, my lord, the officer of the insurance company RW1 has been examined. And in respect of the other defense, my lord, that the auto rickshaw driver had no driving license, RW2 Gurumurthy RTO of my lord Ramnagaram has been examined. And RW3 my lord Rangegowda RTO of Electronic City my lord has been examined, which clearly my lord shows that my lord the driver of the auto rickshaw had no valid driving license at the point of that. And even the permit my lord was beyond the permitted area.
No, that's it. You have not preferred any appeal. We cannot consider.
No, I am not preferred, my lord. I am just pointing out, assisting the court regarding that. Pay and recovery order has been done, my lord. We have not preferred an appeal. Why I am making a submission and apprising these facts to your lordship is that it does not require any modification.
Yes.
My lord, only a small submission, my lord. My lord, only small submission, my lord. My lord, as my learned friend draw the attention of IMU report, I noticed that the history given forthcoming in the medical records and IMU report, it does not tally. My lord, IMU report shows that, my lord, this auto rickshaw is a severely damaged, front right headlight and steering, there is all damaged. Well, it probabilizes, my lord, the driver of this auto rickshaw came in a rash and negligent manner as stated in the FIR itself. My lord, these accident occurred. So 30% negligence, my lord, is unsustainable in the eye of law, my lord, because the evidence itself shows, my lord.
Yes. Please come. Agreed with the orders passed in MVC number 5823 of 2011. dated 28th September 2013. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of ₹6 lakhs for the injuries sustained by the claimant in the accident. The facts of the case are on 14/6/2011 at about 7 p.m. on Bangalore Kanakapura Main Road, when the claimant was riding the motorcycle. Ask him to mute his. On Bangalore Kanakapura Main Road, when he was riding the motorcycle, the driver of the auto drove the same in a rash and negligent manner from opposite side and dashed against the motorcycle. And the claimant had sustained injuries. And thereafter, the said auto proceeded and dashed against another motorcycle. According to the claimant, after the accident, he was shifted to the Sairam Hospital and he took treatment in the said hospital as an inpatient and underwent surgery and discharged from the hospital. As per the evidence of the doctor, the claimant had sustained 14% disability to the 42% disability to the limb and 14% to the whole body. According to the claimant, he was working as an agriculturist and earning how much?
But according to me, I am earning 12,000 per month.
12,000 per month. The court had considered the aspect that
No evidence for not have been there.
the driver of the auto rickshaw was not having a valid driving license to drive the vehicle, and basing on exhibit R. What is that exhibit? Exhibit B4, R4. Exhibit
R1
B1.
is
Exhibit B1, exhibit R1. Basing
R1, exhibit R, medical legal register.
Medical legal register extract. The court has come to the conclusion there is a contributory negligence on the part of the claimant and held that that is assessed at 30%. And when it comes to the liability, the court has held that the insurance company is liable to pay the compensation and recover the same from the owner of the vehicle. Coming to the compensation, the court had taken the disability at 10%, whereas the doctor had, as per the evidence of the doctor, it is 14% per 14% to the whole body. Court has come to the conclusion that on what basis he has come to 14%, there is no explanation forthcoming, and court had taken 10%. When it comes to the salary, court had taken the salary at 4,500, and court had granted 15% future prospects.
6,750 melody. Total.
4,500 plus 15% future prospect. Court had taken 6,750 as the income. No, court had taken 4,500 and future prospects taken at 15%, and the total income is taken at 6,750 into 12 into 16 and to 10. The loss of future earning is taken at 1,29,600, and towards considering the fact that he had taken treatment as an inpatient, court had granted 10,000 towards attendant, nourishment, and for the loss of income during the lead-up period, for 2 months, court had granted 16,500 and rupees 30,000 under the head of loss of amenities.
But loss of income taken at 50,000, is on the higher side.
And
Same
granted,
standard.
loss of immunity is 30,000 is granted. And the sum of rupees 25,000 at the head of pain and suffering. For discomfort and mental stress, an amount of rupees 6,000 is granted. Further, for the future, for the future medical expenses, an amount of rupees 25,000 was granted. Towards medical expenses, 1,84,778 is granted. Altogether, a compensation of 4,26,878 is awarded by the tribunal. As the contributory negligence is calculated at 30%, court has held that the claimant is entitled for an amount of rupees 2,98,830.
850.
$830.
Yeah, please.
2,98,830. The aggrieved thereby, the claimant is before this court. Learned counsel appearing for the claimant submits that the contributory negligence fixed at 30% on the claimant is without any basis. He submits that all the medical reports supports a case of the claimant that the accident had taken place because of the rash and negligent driving of the driver of the offending auto. It is submitted that even exhibit P3 that is IMV report also supports the case of the claimant that there is a lot of damage to the auto, shows that there is the offending auto is at fault. He submits that basing on exhibit P1, exhibit R1, court had fixed the liability at 30%. It is submitted that when the insurance company is saying that there is contributory negligence, the burden lies on them to prove that there is contributory negligence and the same was not proved by the insurance company. In that case, a court ought not to have fixed the contributory negligence at 30%. It is further submitted that no evidence, no one is examined by the insurance company in support of the same. No doctor is examined. It is submitted that the court had taken the disability at 10% when the evidence on record shows that the disability as per the doctor is 14% to the whole body. Learned counsel further submits that on the heads of pain, suffering, and attendant nourishment. And on all, and the amount that is granted by the tribunal is on the lower side. And the same needs to be enhanced. Next para. Learned counsel appearing for the respondent insurance company submits that the court had rightly granted had in fact should have fixed the liability at 50%, contributory negligence at 50%. Instead of that, court has fixed only 30%, and that requires no interference from this court. It is submitted that exhibit R1 clearly shows that while he's overtaking the vehicle, the other vehicle, the accident had taken place, and the contributory negligence ought to have been at 50%. He further submits that there is no evidence on record to show what is the income of the claimant. Further, court for the loss of income, court had considered the future prospect at 50% when the disability, even as per the doctor, is 14%. And it will not, when there is no evidence to show that it will not impact his future earning, the court ought not to have granted the future prospects. It is submitted that the compensation that is awarded by the tribunal is already on the higher side. No interference is called for. Next para, having heard the counsels on either side, there is the material on record. the claimant is before this court on two grounds. One is for enhancement of the compensation and the other is on the contributory negligence. First, coming to the aspect of contributory negligence, all the police records show that because of the rash and negligent driving of the driver of the auto, the accident had taken place. The insurance company is relying on exhibit R1, that is the extract of the that is the extract of the medical legal register. As per the same, the accident had occurred while the injured was trying to overtake the other vehicle. He met with an accident. Basing on that, the court had fixed the contributory negligence at 30%. Admittedly, in this case, when the insurance company is pleading contributory negligence, except filing exhibit B1, no other person is examined in support of the case. Whether who has given the said statement to the hospital authorities is also not forthcoming from exhibit R1. No, the insurance company had not examined anyone on their behalf. When all the police records clearly shows that there is a
Officer of the insurance company has been examined as honorable, who speaks about.
except the officer of the insurance company, no other person is examined from the hospital side with regard to exhibit R1. When all the police records clearly shows that there is negligence on the part of the driver of the auto and the crime is registered against the driver of the vehicle. When the insurance company is pleading contributory negligence, they should have adduced cogent evidence to put forth their case. In this case, basing on exhibit P1 alone, the R1 alone, court cannot come to such a conclusion that there is contributory negligence. Hence, this court is of the view that the set finding of the court fixing the contributory negligence at 30% on the claimant needs to be set aside. Then coming to the injuries, as per the exhibit P5 discharge summary at para number 23, you just extract all this 1 to 6. These are the injuries. Considering the multiple injuries that the claimant had sustained under the head of pain and suffering, this court is granting an amount of rupees 80,000. Then coming to the income, considering that this is an accident of the year 2011, and considering the nature of injuries for 4 months, 6,500 into 4, this court is granting an amount of rupees 26,000 towards loss of income during the later period, considering the hospitalization of 50 days, transport, nourishment, and attendant charges, an amount of rupees 30,000 is granted. Towards loss of amenities, amenities. This court is, the trial court had granted an amount of rupees 30,000, which this court is not interfering with. Then coming to the future medical expenses, an amount of rupees 25,000 is granted. And medical expenses, 1,84,778 is granted. On that also, this court is not interfering. Then coming to the loss of future earning capacity, the court has considered 50,000 future towards loss of earning, towards the future loss of earning, and 50% is considered. Considering the evidence, the medical evidence, and the disability, this court is not inclined to grant the same. When this court has taken the income at 6,500, as per the evidence of the doctor, the claimant had sustained 14% disability to the whole body. What is the multiplier?
16.
Coming to the disability, considering the evidence of the doctor and the condition of the claimant, the court had rightly taken 10% as a disability, and this court is not interfering with the same. And it's taking the income at 6,500 into 12 into 16 into 10 by 100 is 1,24,800. In the light of the law laid on make loss, so and so legal expenses, 10,000. Altogether, the claimant is entitled for an amount of rupees 5,10,578. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 2,98,008 from 2,98,830 to 5,10,578.
Pay and recovery, my lord, has to be, my lord.
And it is that as far as the said amount is shall be paid by the insurance company and record the same from the owner of the vehicle. Yes, next.
Cell number 9. Suresh from Latur.
Why they are they required? Translated
According to
copy.
me, not required, not required.
Where is he? Ask him to come at 2:30. Let him argue. Now, even this is also translated copies which are not required. Earlier case also. We'll hear it at 2:30. Day after tomorrow.
Please.
Yes, next.
10. Krishna Kishore S for appellant.
As per the orders,
Memo for acceptance of paper.
as per the order passed by this court,
Sujata.
paper publication has been taken. And the memo for acceptance, the paper publication is filed in respect of R2 to R2 A to C. Accordingly, the same is accepted. Notice to so and so held sufficient. Yes, is this matter for hearing? Yes, next.
Cell number 11. AM Venkatesh. Steps to be taken in respect of R1 to 3.
Yes, shall come up with an appropriate application seeking substitute service of notice. Within how much time?
Times.
How much time?
1 week.
A week's time, default order. Yes, next.
Cell number 12. Ravi Kumar. Non-furnishing of cover.
No representation list for dismissal on Friday.
Cell
Yes,
number
next.
13. 13. O Mahesh for appellant.
Yes, Mr. Mahesh.
O Mahesh sir. O Mahesh sir. Sir, O Mahesh sir. Bringing a loss of this is not the,
Who appears for the respondents?
that is Harish Kumar MS. Harish Kumar.
Pass over.
Cell number 14, 14 urgent. Cell number 15. Nagaraj Jagde.
Yes. Pradeep.
Please.
I number 1/16 is filed to condone the delay of 18 days in filing the appeal for the reason stated. The delay is condoned. This is matter for admission. Seeking enhancement.
The check issued towards premium it got once not, the policy has been cancelled. The liability fixed against the owner of the vehicle. That they have question.
ECR is required.
Required.
ECR required.
Required.
District is directed to call for the TCR. After the TCR is received, this is matter for admission.
Cell
Yes,
number
next.
16. Ravi Shankar Shastri.
For respondent number 2 in this matter.
On condition. On condition. I number 1/17 is filed to condone the delay of 2 or 3 days in filing the appeal. No objections are filed by the respondent. However, considering the delay of 2 or 3 days, the same is condoned on the condition that they'll not be entitled for interest in the event of in the event they succeed in the appeal.
Cell number 17. ME Nagesh.
Respondents, my lords. My lords, matter may be posted for final hearing. Matter may be posted for final hearing.
No, it was,
So then IA will be, shall we dismiss IA 1/24?
Your Lordship said that today that will be heard, Mary, this one. Because that I have deposited, that liability is concerned, it's based on.
Say that they're not pressing for it and they will, matter has to be heard.
Please, my lords, by next week, it may be posted for final. hearing.
Next week it is not possible, 17 matter. This is matter on 22nd of April, 17. It is submitted that they are not pressing on IA number 1/24. This is matter for final hearing.
Cell number 18. TP Mahesh.
No representation for dismissal next week. Yes, next.
Cell number 19.
Corresponding number 4, my lords.
Pantrajappa MG.
Give that. No representation on behalf of the petitioner. This is matter for dismissal. Next.
Cell number 20. Data. Cell number 20. Sitaram Rao. For appellant. K. Nagalingappa.
I appeal for respondent. Responding.
No the appellant, counsel, respondent is present. List is both the matters for dismissal next week.
Cell
Yes,
number
21.
21. T. Sheshgiri Rao.
They appear for the respondent.
Counsel, respondent is present, no representation for the appellant for dismissal.
Cell number 22. Nagbhushan S.
Applying for the appellate, my lord. Prayer for 1 week, man.
Why?
HR Renuka.
The senior is busy in the other court hall or Passover, my lord.
This is 2 matters on 16th of April.
Cell number 23. Nagabhushan S.
Here is Mr.
Ashok
Ashok
Patil.
Patil.
For the respondent number 1 claimant, my lord, I have filed application for withdrawal. I have filed application for withdrawal of amount, my lord.
No representation for the appellant. This is matter for dismissal tomorrow. Yes.
Yes. Cell number 24.
Yes, Mr. Pradeep.
24 Pradeep B.
This case, my lord, challenging the liability on the ground that 24.
I appear for.
Only on the ground of liability.
Liability and quantum, my lord. Quantum is concerned, my lord, that it's a ECA matter, my lord. The MSCT has considered 9,000 income instead of 8,000 as per notification. And my lord, 1/3 has been deducted towards personal expense. It is
much?
wrong, 1/3 deducted. That deduction would not arise, my lord. 50% has to be taken for compensation grant. my lord. So liability is concerned, my lord, as per the exhibit P1 FIR, to clearly indicated that, my lord, the deceased was sitting on a tractor. He fell down from the tractor, was sitting on a mudguard, my lord. The risk of that person is not covered. The sitting capacity of the tractor is only 1 wheel, as per road regulation 28. my lord. He should not travel on the tractor. my lord. The MSCT coming to the conclusion that in the charge sheet filed, I was sitting on a trailer. The very complaint given by an eyewitness who has clearly stated and clearly given complaint. The complaint itself, my lord, clearly demonstrates that he was sitting on a mudguard and he fell down from the mudguard. Then only the tractor wheel has ran over on him.
No, complaint is given.
Please.
Thereafter, the charge sheet is filed.
Regarding that, my lord, the contents of the FIR should be looked into. Yeah, as per the
No,
judgment of
it's
the
a
apex
first
court.
document, no doubt.
Please.
But ultimately, when the charge sheet, after completing the full-fledged investigation, what would consider it the charge sheet? Next document.
Please, my lord, charge sheet itself is not a conclusive proof, my lord. They have to examine the.
It's not a conclusive proof.
Please, my lord, they have to examine the independent.
FIR is also not an encyclopedia.
Please. But they have to establish their case that, my lord.
No, then the document is charge sheet. Later, then the acquittal or conviction. So as of now, when FIR charge sheet, 2 documents are there, we have to look at the charge sheet, not the FIR. Then that's one aspect, any of that will not consider. Now, the second one is with
Second
regard to the
income.
income. Let's go to that. Where is that?
Please. my lord. Income is concerned by para 12 of the judgment. my colleagues. Internal page 10, my lord.
Income is taken as 9,000 according
9,000.
to you, 8,000.
8,000.
What do you say on that?
My lord, I am the owner of the vehicle, my lord. My lord,
Respondent number 1 and 3.
my lord, before that, my lord, the entire amount, my lord, which is deposited, my lord, they have also withdrawn that amount by the claimants, my lord. And also, my lord, regarding, my lord, liability. The
No, liability, I've already said that.
Please,
Not
madam.
considering.
Please, I
on the calculation.
have no objection, my lord, regarding the income. Income has to taken, my lord.
Taken to be 8,000. As per the notification, it is 8,000, but it's 9,000.
Please.
Then the question of 1/3 will not arise. 50% has to be deducted.
He is the claimant, my lord.
That's why I'm only
Please.
asking him.
Kindly pass over.
Pass over,
Please.
look at it. And that's the only thing remaining to
Please.
be decided. Yes, next.
Tell number 25, Syed Abdul Sabur for appellant.
No representation on behalf of either of the parties. This is matter for dismissal.
Tell number 26,
Yes.
Sharat S. Gowda for appellant.
Yes.
Started matter
Shivana Gowda.
regarding the citation. Last time I have taken time. May I pass it on the.
Take that.
I have cited the Supreme Court judgment. Your
You are ready
lordship
to
has not.
argue?
Please, my lords.
Give him a copy of it.
Blood in this.
Mm.
The scenario of this case, my lord, the driver is not having a driving license. Therefore, my lord, court has directed the owner of the vehicle to pay the compensation. Similar to this, my lord, the Disaba court has, basing on that, my lord, I have cited the Supreme Court judgment where the pay and recovery was not ordered. But your lordship says that the finding was not given, therefore I will not agree for the judgment which was referred. The similar line of the argument, my lord, considering the Swaran Singh case and all other cases, where the Disaba court has held that, my lord, question of pay and recovery does not arise. Therefore, your lordship kindly. The citation which was pay and recovery was referred by the that Chikkappa case, Annaya and Swaran Singh case and Roshan New India versus so and so. Malad, para 6 of the judgment from onwards, Malad, it is what is regarding the LME what license was he was having, he was driving a vehicle and the para 7, the distinction was given. The policy in question does not cover the risk of the employee of the vehicle. Though there is a combination vehicle, no premium was collected, liability paid the driver of employee. Driver was claimant who has been, the prosecuted the allegation rash and negligent. This is very rash and negligent of driving up for the casting of the accident. Section 3 of the Motor Vehicle Act for the contemplates the necessity of holding effectiveness. No one can drive the transport vehicle in a without a license issued by the specifically entitled to him to drive. Section 4 of the Motor Vehicle Act contempt age of restriction contention the connection with the driving of the motor vehicle. Section 5 of the Motor Vehicle mandate the owner of person in charge a vehicle from permitting the any person to drive a vehicle or motor vehicle who does not satisfy the provision of Section 3 and 4 of the Act. It is one of the insurance policy condition, the person driving holds an
Now,
effective, please. In this case, my lord, court has observed.
There is another angle to this. Now, under the Workmen Compensation Act.
Correct.
The employee, now even under the Motor Vehicles Act also, with regard to the valid driving license and all, the burden is on the owner, it is the burden of the owner to verify the driving license.
Correct.
Now, in a given scenario, if the owner has made him to drive a vehicle for which he is not having a driving license.
Correct.
The license, the policy of insurance is between the owner and the insurance company. It is a clear default on the part of the owner letting him drive a vehicle.
Not
So why
only-
should this theory be?
Not only that, my lord,
Then,
knowing fully well that the driver is not having a driver, he driver the vehicle.
but he was compelled to do
Negligence
it.
on that.
No, I'm saying, why
That is-
not the other part?
It is
of it?
true, my lord. It is true, my lord.
Huh.
If that being the case, he should have established by producing or examining somebody. Compulsion was not forthcoming before this court. Therefore, you are also kindly parallel 11
Whose
of the
case is
judgment.
that? Whose case at any, now, let us go to give the. When this, arising out of the Workmen Compensation Act.
Please, ma'am.
When the owner has not taken the care, so he should be penalized
No,
for
no, no.
paying the money.
My lord, knowing fully, assuming that, my lord, knowing fully well that there is a fraudulent act which I am committing.
Show some
For
judgment
that,
of
my
the,
lord,
no, show some judgment of the division bench or a Supreme Court judgment. Because my view on this is not,
then,
not like this.
please, my lord, that.
No, that's why I'm saying, if I have to take a view like how you are submitting, let there be a Supreme Court judgment or a division
No,
bench judgment.
Apart
Or
from
else I
this,
have
my lord, there is no other judgment regarding the ECA Act concern. What they observed in this judgment, my lord, he is not a third party. Driver is not a third party. Therefore, third party
So
decision
let
which
us
is.
say, even in an ME Act also.
Please.
Somebody is, he is the deceased is the person who is driving the vehicle without a driving license. Deceased is driving the vehicle and he has no driving license.
No, he cannot claim a compensation under the motor vehicle. He has to approach only in ECA Act.
Now,
That's the
again,
reason.
EC Act also same,
No, that's what, my lord.
no, I'm asking you under the Motor Vehicles Act.
If
What would be
he-
the position?
He claim, my lord, his claim petition is not made. If he is a driver by a profession, he was.
Not by profession. I'm saying a person is driving the vehicle without a driving
I am
license.
liable to pay insofar as third party is concerned under the Motor Vehicle Act.
What is
I
that?
have no brief. Insofar as third party's liability is concerned, I am liable to pay and recovery order has to be taken. Because whether it is a negligence on the part of the driver of the vehicle or owner of the vehicle, I need to satisfy the award insofar as the third party. The scenario of pay and recovery is, my lord, they are not able to recover the amount from the owner by initiating. That is the reason pay and recovery was 149(5). Using that, my lord, the Supreme Court has held that, my lord, pay and recovery because they are the third parties. Here is the driver is not a third party. The observation of the apex court in that Beliram
Why he is
case,
not a third party to the insurance?
because, my lord, he is stepping to the insured, the shoe of the insured. Third parties are concerned, they are not stepping to the insured, my lord. Therefore, I have to satisfy the award. Here is the case, my lord. He is stepping to the insurer. He is not a third party. Therefore, employee is not a third party.
All the more it is the responsibility of the owner of the vehicle to check all this.
No, it is the duty, no, the person who was approaching the court, he has to satisfy that he is having a valid driving license to drive the vehicle. To get the compensation, man, for the negligence, his own negligence, he cannot maintain a claim petition. That is the reason, my lord, under the WC Act, the proviso was made to pay the compensation if he won't that, he has satisfied that he had a driving license, he has not violated the any terms and conditions,
Which
then he is.
provision says, let's see. Workman Compensation Act.
Your lordship kindly observe the workman, the meaning of the workman.
It says employee.
Please. Person. Employee means so and so. Last one, my lord, person restricted to work abroad company, person restricted to a driver, helper, mechanic, cleaner, or any other capacity in connection with a motor vehicle. But the 149 says, the section 3 of the motor vehicle says, my lord, no person are authorized to drive the vehicle unless he holds a valid driving license in a public place. But the policy was issued under the motor vehicle act, wherein the coverage was given to the employee based on the seating capacity of the vehicle. Insofar as third party is concerned, basing on the statutory provisions, I am required to cover to the extent of seating capacity. Here, my lord, it is not a statutory coverage, but under the WC Act, my lord, I have to required to cover the risk of the driver and the police in a goods vehicle or in the conductor in the case of the passenger vehicle. My lord, in order to drive the vehicle, my lord, he must have a valid driving license to drive the vehicle. That was not, yes, for his own negligence, my lord, he has not, in this case, he has not renewed the license on that day. But knowing fully well that, my lord, he is not having that. He is without a driving license, he is driven. Not pay and recovery, where, my lord, the third parties are involved, then the liability will be arise. Here, my lord, he is not a third party. As observed in both the case, my lord, para 11 of the judgment which I have cited, your lordship, is say, rightly appellant raise the question, liability to indemnify the owner on the ground of breach of policy condition. The workmen are not a third party whose risk is covered by in the policy. There is no obligation for the appellant. They comply the compensation of 2 counts. Firstly, on the breach of policy condition, and secondly, no premium was. Here, my lord.
And what are the judgments that they were relying upon on the other day?
No, they have not given any citation.
They didn't,
Still, they have not commenced. Basing on my argument, your lordship has not convinced on that day. And that's the reason it is urgent.
yes, you can
Correct.
respond on this.
Please, my lords.
Mrs. Martha next week as part her.
So number 27.
I am for the appellant in all the 9 cases, my lord. Records are needed, my lord, because I am relying on a few documents where the wound certificate and the injury are not matching, my lord. That is why even My lord. Yes, ma'am. It's quantum only. All the people were traveling in the leased bus, my lord. The accident has happened and the tribunal has awarded some amount, my lord.
DSP is directed to, why, when was the TCR called for?
Last statement.
In 2 weeks back, I think.
Last statement. Last week.
This on last occasion it is called, it is on 24/2, madam, 24/2.
Why it is no, why it has not come? Though already already an order is passed calling for the TCR. Is this matters after the TCR is received? Yes, next.
Date may be fixed, Manaship. Date may be fixed, Manaship.
Yes, next.
The one of it.
Yes.
List number 2. Sale number 1, Kemparaju.
Krishna, my lords, I may be permitted to convert it into criminal petition, my lords, because I sought for transfer of CMIS. I sought for transfer of CMIS, my lords. I may be permitted to convert it.
Petition is permitted to convert this petition as the present petition is filed seeking transfer of criminal miscellaneous pending before the trial court. Yes. Yes, yes, next.
For orders matter, sale number 2. Memo for withdrawal of the petition.
The memo is for seeking to withdraw the petition. Accordingly, the memo is taken on record and the petition is dismissed as withdrawn.
Sale number 3 and 4 disposed. Sale number 5. Prabhugaud Timbigi, compliance of office objections.
No representation for dismissal tomorrow, next date, give the date.
Next week, ma'am. Sale number 6 adjourned. Sale number 7.
It's appearing for the
Kindly
paid for the
pass over,
appellants in
my lords.
MSA 76, my
Kindly
lords.
pass over, my lords. We'll file memo for dispensation on the PF to be paid from R2 to R18, my lords.
Which case?
First, my lords.
Sale number,
Seven.
list number 2, serial number 7.
7, list number, serial number
Pass
7.
over.
Sale number 8.
This is
As far as these objections go, my lords, the
Not
first.
taking the steps to bring
Lords,
the
yes.
LF of this is.
I have filed necessary applications. I don't think it's been put up, my lords. My lords, it's been filed. It'll be,
It is submitted that the
Please,
application is already filed.
My lords,
It's
I
still directed to
have
put up.
one
this.
submission, my lords. The second objection, my lord, on the cause list, I think that's incorrect. My lord, it says non-taking of steps, yes. Not in respect of deceased A1, my lords. It should be deceased A7. A1 is still alive. We've not reported A1's death.
So you have to take steps.
I have taken steps, my lords. It's just that it says A1 that may cause some issue with the
She
registry.
submitted that in respect of deceased A8 and A7.
Please, my lords.
Steps are taken.
A8, R7, yes, my lords.
A8 and A7, the steps
Please.
are taken.
In the
And
second
the
one,
registry is directed to place the same before the court.
please. In the
Next.
second one, it says A1, but it should be A7. I have taken steps.
Yes.
Please,
Yes.
my lords.
Sale number 9.
Non-compli. Who is Ajit Anand Shetty?
Ajit Anand Shetty for R4 to 9.
Yes, list this matter. After, give the date next week. Yes.
Sale number 9.
No, I'm sorry, was a date given?
For-
Was a date given? I may not have heard.
She'll
Please,
give
my lords,
the date
I'm
next
grateful.
week.
I'm grateful.
Yes.
Take the
Obliged. I'm obliged.
Sale number
Yes.
9, VB Sidramaya.
For the respondent number 2 in this beneficiary in this matter, my lord. In the trial court, they have not made party, beneficiary as party.
Same,
Maybe
where is the counsel for the appellant?
was here, warning was.
No representation for the counsel for the appellant, or the counsel for the respondent are present. Let's just matter for dismissal next week. Yes, 10.
Sale number 10. Sale number 10. K. Shashikant Prasad. Respondent.
Representation, same order.
11. 11. Krishnappa NR. Maintainability of appeal.
Same order.
So serial number 12,
No.
For a Passover, my lord, at
We'll
2:30.
have it after lunch. Even from 11 you call after lunch, it's already 1:30. Even from 10. Not from 10, from 8 you call. What is represented? 8 is represented?
8 is ordered.
Huh?
9 is ordered. 8, there is 8 is ordered. 8
Oh,
represented.
no, from 9, from 9 you call. You call after at 2:30.
My lord, a humble submission, my lord. See, list number 1, serial number 28. On the last date, both the kids were ordered to be brought to court at 5 p.m., my lord. But now on the causes, my lord, it is mentioned as 2 p.m., my lord. So the mother's bringing the kids here and she'll be here by 5 p.m., my lord. So it's been mentioned as 2 p.m. I was just wanting to
Because
inform.
today it is like the court is still 3 for the, 3
Sorry?
for. Today there is reference. That's why they are mentioned like that.
Okay, my lord. I'll ask her to make it as early as possible by 4 if possible, my lord. Much obliged, my lord. Serial number 23 ಏನಾಯ್ತು ಮೇಡಮ್?
Madam, serial number 18. First list of serial number 18. Madam.
List.
Serial number 18.
ಮೇಡಮ್ ಇದು 23 ಏನಾಯ್ತು ಮೇಡಮ್? serial number 23 list number 1. 14/3 ಬರುತ್ತಾ? Friday.
Number 3 and date for wait ಮಾಡಿ.
ಮೇಡಮ್ ಇದೆಲ್ಲ 8ಗೆ ಒಂದು ಡೇಟ್ ಕೊಡ್ಬೇಕಲ್ಲ? ಯಾವ್ದಕ್ಕೆ 8ಗೆ? ಹೇಳ್ತೀನಿ. ಯಾವ್ಯಾವ್ದಕ್ಕೆ ಡೇಟ್ ಕೊಡ್ಬೇಕು ಹೇಳ?
ಇದು 27 ಒಂದು ಡೇಟ್ ಕೊಡ್ಬೇಕು. ಪಾಸ್ ಮಾಡೋದು ಡೇಟ್ ಕೊಡ್ತೀರಾ?
ಒಂದ್ ನಿಮಿಷ. ಹೌದು ಹೌದೌದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಒಂದು
ಹಿಂದೆ 25 ವರೆಗೂ ಕೊಡ್ರಿ.
ಮೇಡಮ್ ಮೇಡಮ್
ಸೀರಿಯಲ್ ನಂಬರ್ 26.
ವಾಟ್ ಆರ್ ಸರ್?
26 ಪಾರ್ಟ್ 2 ಅದಕ್ಕೆ ಡೇಟ್ ಕೊಡ್ಬೇಕಲ್ಲ ಸರ್? ಒಂದ್ ನಿಮಿಷ.
ನಮಸ್ಕಾರ. ಅದೊಂದು CP
24/9 21/30 24 ಕೊಡಪ್ಪ.
27 ನೋ ಡೇಟ್ ಕೊಡ್ಬೇಕು.
20
ಹೇಳಿದ್ರು.
ನಮಸ್ಕಾರ
ಡೇಟ್ ಕೇಳಿದ್ರು.
ಆಫ್ಟರ್ ಅದೇ ಏಪ್ರಿಲ್ ಅಲ್ಲಿ ಒಂದು ಡೇಟ್ ಕೊಡ್ತೀನಿ ಅಂತ. ಒಂದ್ ನಿಮಿಷ. ಏಪ್ರಿಲ್ ಅಲ್ಲಿ ಇದು 3, 4 4ನೇ ತಾರೀಕು ನೋಡಿ ಏನಿದೆ? 7/4 ಕೊಡಿ. ಸೀರಿಯಲ್ ನಂಬರ್
ಯಾಕೆ
ಅಲ್ಲಿ 7/4
ಕಾಲ್ ಮಾಡಿದ್ರೆ ಮಾತಾಡಕ್ ಆಗೋದಿಲ್ಲ.
ಆಮೇಲೆ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲಿ ಒಂದು ಡಿಸ್ಮಿಸ್ಡ್, 2 ಡಿಎನ್. ಸೀರಿಯಲ್ ನಂಬರ್ 5 ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಎಲ್ಲ. ಅದು ದಟ್ ಈಸ್ ಆನ್
ಅಲ್ಲ ಎಲ್ಲಿದೆಯಪ್ಪ? ಇಲ್ಲಿ ಕೋಟ ನಂಬರ್ 24 ಹತ್ರ ಇದೀನಿ.
27 ಸರ್. 27
ಬರ್ಲಾ
ಕೊಡಿ.
ಮೇಲಕ್ಕೆ ಬರ್ಲಾ ಕೇಳಿ.
27
8 1 ಕೊಡಿ ಮೇಡಮ್ ಅಷ್ಟೇ.
7 ಪಾಸ್ ಓವರ್ 8 1 ಕೊಡ್ಬೇಕಲ್ಲ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಡೇಟ್ ಕೊಡಿ ಎಂದು. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ
9 ಇಂದ ಮೇಡಮ್ ಗೆ ಕೊಡ್ತೀನಿ.
ಡಿಸ್ಮಿಸ್
ಮೇಡಮ್ ಸೆಕೆಂಡ್ 13ನೇ ಮೀಟರ್.
13ನೇ ಮೀಟರ್.
27
ಮಧ್ಯಾಹ್ನ
ಮೇಡಮ್ CP
Madam, right.
Sir,
Portal, see list number 2 ಒಂದು ಸ್ವಲ್ಪ ಫೈಲ್ ಬೇಕಾಯ್ತು.
Second list 5.
one ನಿಮಿಷ sir. 220.
List number 2.
ಹೇಳಿ
List
sir.
number 2 ಒಂದು ಸ್ವಲ್ಪ ಫೈಲ್ ಬೇಕಾಯ್ತು.
Serial number 19.
CP 475, 476 ಇದೆಯಲ್ಲ?
ಹೇಳಿ sir.
ಅದ್ 18. ಅದು ಇನ್ನೊಂದು ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಅಂತ ಹೇಳ್ಬೇಕಾಗಿತ್ತು, ಇನ್ನೊಂದು CP ಅಂತ ಹೇಳ್ಬಿಟ್ಟದೆ, ಅದಕ್ಕೋಸ್ಕರ ಅದ್ ನೋಡ್ಬಿಟ್ಟು ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ತೀನಿ ಮತ್ತೆ.
ಅಲ್ಲ
ಕೊಟ್ಟೆ, ಅದೇ ಕೊಡಿ, ಅದಕ್ಕೆ ಚೇಂಜ್ ಮಾಡಿಸ್ತೀನಿ ಒಂದ್ ಸ್ವಲ್ಪ ಫೈಲ್.
ಇವತ್ತು ಆರ್ಡರ್
ಅದಕ್ಕೆ ಕೊಡಿ ಹಿಂದೆ.
ಹೇಳ್ಬೇಕಾ?
ಫೈಲ್ ಕೊಟ್ರೆ ನಾನು ಕರೆಕ್ಟ್ ಆಗಿ ನೋಡ್ಬಿಟ್ಟು ಹೇಳ್ತೀನಿ ಹಿಂದೆ. ಇವತ್ತು ಆರ್ಡರ್ ಮಾಡಿಸ್ಕೊಂಡು ನಾಳೆಗೆ ಇದ್ ಮಾಡೋಣ. 2:30
ಇವ್ರು ಬರೀ ಯಾವಾಗ್ಲೂ ಬರೀ ಜಗಳ ಆಡಕ್ಕೆ
ಜಗಳ ಆಡಕ್ಕೆ
ನಾವು
ಬರ್ತಾರೆ ಇಬ್ರು.
ಮಾಡ್ಲಿ ಸುಮ್ನಿರಪ್ಪ.
ನೀವು ಮಾತಾಡ್ಲೇಬೇಡಿ ನೀವು.
serial number ಎಷ್ಟದು ಪಾಸ್ ಓವರ್ 13. ಓಮಯ್ಯ ಸರ್ ನೋ ಇವರು ಕನೆಕ್ಟ್ ಆಗ್ಬಿಟ್ಟು ಎಲ್ಲೋ ಹೋಗ್ತಾರಪ್ಪ. ಸರ್ ಓಮಯ್ಯ ಸರ್ ಇದ್ದೀರಾ? ಅದು ಇದೆ, ಅವರು ಆನ್ ಮಾಡ್ಬಿಟ್ಟು ಹೋಗ್ಬಿಡ್ತಾರೆ ಆಚೆ ಅನ್ಸುತ್ತೆ ನೋಡಿ. ಅವ್ರದ್ದೇ ಮ್ಯಾಟ್ರ್ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ 13ನೇದು.
ಕೋರ್ಟ್ ಕಾಣ್ತಾ ಇಲ್ಲ.
ಕೋರ್ಟು ಕಾಣಿಸುತ್ತೆ ಸರ್ ಈಗ. ಈಗ ಸರ್
ಕಾಣ್ತಾ ಇದೆ.
ನಿಮ್ ಸ್ನೇಹಿತರು ಓಮಯ್ಯ ಸರ್ ಇಲ್ಲಿಗೆ ಒಂದ್ ಸ್ವಲ್ಪ ಮಾತಾಡಕ್ ಹೇಳಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಅವ್ರದ್ದು ಒಂದ್ ಮ್ಯಾಟ್ರ್ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ 13ನೇದು.
ಅಡ್ಡಿಲ್ಲ, ಈಗ ಹೇಳ್ತೇನೆ ಅವ್ರಿಗೆ.
ಅವರು ಇಲ್ಲಿ ಕನೆಕ್ಟ್ ಆಗ್ತಾರೆ, ಆಮೇಲೆ ಹೋಗ್ತಾರೆ ಅಲ್ಲಿ ಎಲ್ಲೋ ಇರೋದೇ ಇಲ್ಲ ಆಫೀಸಲ್ಲಿ.
ಇಲ್ಲಮ್ಮ, ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇರ್ತಾರೆ, ಬೇರೆ ಇದ್ರಲ್ಲಿ ಇರ್ತಾರೆ.
ಹೌದಾ? ಇಲ್ಲೊಂದು ಪಾಸ್ ಓವರ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಅವ್ರದ್ದು, ಮತ್ತೆ ಇವಾಗ ಹೋಗುತ್ತೆ ಡಿಸ್ಮಿಸಲ್.
ಹೇಳ್ತೇನೆ, ಈಗ ಹೇಳ್ತೇನೆ.
ಆಮೇಲೆ ಅಲ್ಲಿ ಕನೆಕ್ಟ್ ಆದ್ರೆ ಡಿಸ್ಟರ್ಬೆನ್ಸ್. ಅವ್ರ ಮೇಡಮ್
ನೋಡಿ, ಕೋರ್ಟ್ ನಂಬರ್ 25 ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಒಂದ್ಸಲ ಕೋರ್ಟ್ ಆಫೀಸರಿಗೆ ಮಾತಾಡ್ಬೇಕಂತೆ. ಸರಿ, ಆಯ್ತು. ಗೊತ್ತಾಯ್ತೇನಮ್ಮ? ಹೇಳ್ದ?
ಆಯ್ತು ಸರ್.
ಹೇಳಿ ಮೇಡಮ್.
ಸರ್ ನಿಮ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ 13 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಲಿಸ್ಟ್ 1 ಅಲ್ಲಿ. ಕೇಸ್ ಕರೆದಾಗ ನೀವು ಎದ್ದೋಗ್ಬಿಟ್ಟಿದ್ದೀರಾ.
ಇಲ್ಲ ಮೇಡಮ್, ಇಲ್ಲೇ ಬೇರೆ ಕೋರ್ಟ್ ಇದೆ.
13 ಪಾಸ್ ಓವರ್ ಅಲ್ಲಿ ಇದೆ. ಏನಾದ್ರು ಸಬ್ಮಿಷನ್ಸ್ ಇದ್ರೆ ಕನೆಕ್ಷನ್ ಅಲ್ಲಿ ಇರಿ.
ಸರಿ.
ಪಾಸ್ ಓವರ್ ಕರೀರಿ ಅಂದ್ರೆ ನಿಮ್ಗೆ ಫಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ಕಾಲ್ ಔಟ್ ಆಗೋದು.
17 ಏನಾಯ್ತು ಮೇಡಮ್?
17
ಗೋವಿಂದ.
17 22/4 ಹೋಗಿದೆ.
23
ನಾಗೇಶ್.
ಆಮೇಲೆ ಇದು 19
24/3 ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್. 24/3 ಗೆ ಅಂಡರ್ ಕ್ಯಾಪ್ಷನ್ ಆಫ್ ಡಿಸ್ಮಿಸಲ್. ಆಮೇಲೆ
ಓಕೆ.
ನಿಮ್ದು ಮ್ಯೂಟ್ ಮಾಡ್ಬಿಡ್ತೀನಿ. ನಿಮ್ದು ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಆಫೀಸು. ಕೇಸ್ ಕರೆದಾಗ ನೀವೇ ಕನೆಕ್ಟ್ ಆಗಿ. ಅವರೇ ಮ್ಯೂಟ್ ಮಾಡಿದ್ರು. ಅವ್ರ ಮಿಸಸ್ ಮಾತಾಡ್ತಾನೆ ಇರ್ತಾರೆ. ಅವ್ರೇನೋ ಕಮ್ಯುನಿಕೇಶನ್ ಮಾಡ್ತಿರ್ತಾರೆ ಎಲ್ಲ.
ಪಾಸ್ಡ್ ಮ್ಯಾಟ್ರ್ ಎಷ್ಟದವ್ರಿ ಮೇಡಮ್? ಲಿಸ್ಟ್ 1, ಲಿಸ್ಟ್ 2, ಕೋರ್ಟ್ ಆಫೀಸರ್.
Three matters are passed over, sir.
ಹೌದಾ? ಲಿಸ್ಟ್ 1 ದಲ್ಲೇ?
List 1 ಅಲ್ಲಿ 2.
ಓಕೆ.
Serial number 15 adjourn ಆಗೈತೆ ಹೌದಲ್ರಿ? Third list.
AM Venkatesh sir adjournment ತಗೊಂಡಿದ್ದಾರೆ 17-3.
Okay, thank you, madam. Thank you.
Number 13, Omayesh.
Appear for the appellant, Lord. But application 6299, my lord.
Yes, with the respondent.
R3 is reported dead, LRs have been brought.
I-1 of 23 is filed to condone the delay of 2,129 days in filing the LR application. No objections are filed by the respondents. For the reasons stated, the delay of 2,129 days in filing the LR application is condoned. And consequently, I number 2 of 23 is allowed by setting aside the abatement. And I number 3 is also allowed by bringing the LR to the deceased artery, and the appellant shall make the necessary amendment to the cost title within a period of 10 days from today. Yes.
This is now 6.
In 6299, my lord, R3 is dead and LRs have been.
Same in the next also. What about memo for death? R6?
That is filed by the other side, my lord. On that memo only, I came to know the date.
R6, the LR of R6 is.
The I number 1 of 23 is filed to condone the delay of same. This is also ordered. This is also 10 days.
Amend the
Next.
cost title. Serial number 24. Serial number
Yes.
24,
Appear.
which one?
Respondent, ma'am.
Sitting for the appellant.
Where is he? Mr.
Chandresh.
Counsel for the claimant. This matter is part heard on Friday.
14.
Yes. No representation for the land counsel for the claimant. Yes.
Number 2. Serial number 7, Passover.
For the appellant, filing memo to dispense notice with respect to 2 to 18. In the connected appeal also, notice has been dispensed as against respondents. They have,
The voice
the
file seeking
defendant,
dispensation of notice to
R2 to
R1 to
R18.
R1 to R18.
R2 to R18.
R2 to 8.
R1 is the respondent, who's the only contestant.
who are the remaining respondents?
Yes, they're all the defendants. Those are the.
So you have to say who are the different number, how they are arrayed. Just like that, you cannot say that notice to the remaining respondents may be dispensed with.
I'll just mention R2 to.
Please mention the number.
Any lordships?
Number of respondents.
Your lordships, in MSA 76, we had already filed a memo for dispensation, and as per the order of this honorable court on 13/9/24, it has been already dispensed with. However, it is still showing the same in the order in the cause list, my lords. If your lordships.
It is dispensed to R6?
R2 to R18, MSA 76/22, my lords.
Then why is the office not verifying? Notice itself is dispensed with. Where is the question not?
R1 is a sufficient party and.
No, long back it is dispensed with. It is submitted that already notice to R6 is dispensed with. Then what about this LRs of deceased R8? Everything, it is submitted that already notice to respondents 6 to 18.
2 to 18, my lords.
2 to 18.
10 is on
Yes.
record, my lords, in 76. Respondent number 10 is on record. I filed wakalat. Different number
You're
9.
saying 2 to 18.
We had filed it in September, my lords.
22 only.
September.
It is dispensed. For the rest,
That I'm not able to understand. Already notice is dispensed.
with this,
to you
I had personally
also.
entered appearance.
In the year of 2022, he appeared, my lord.
It is submitted that they have already filed a petition seeking dispensation of notice to R6 to R2 to R18, and the same is dispensed with. Yes. Why you're not even looking at how many respondents are there in your case?
In 7.
Respondents are 2 to 17. I mean 1 to 17.
Yes, my lord.
You wanted dispensation 2 to 18. Give the file.
107, there are 18 respondents. In 107, 18 only.
2 to 17, my lords. I apologize, my lords. I bow down.
There are only 17 respondents in your
Yes,
case.
my lord. Please, my lord. I bow down, my lord. I just wanted to bring to your lordship's notice that it has been dispensed with, and R1 is the only relevant party in our matter, our MSA.
No, basing on your memo, it is dispensed with to 18 also.
Yes, my
When there
lord.
are 17.
I bow down, my
respondents,
lord. I bow down.
This court by order dated 13/9/2024 are dispensed with notice to, as basing on the memo 2 to 18, whereas the respondents are 17. Hence, has been considered as dispensation of notice to 2 to 17. Yes, this is matter for for hearing.
The lordships in 107, it may be
Hmm?
dispensed. In MSA 107.
That you can do it right now. You can mention the numbers. Why another day for that?
2 to 8.
MSA number 107, take this order. Memo is filed seeking dispensation of notice to respond. At least in your appeal, there are 18 or 2 to 18. Accordingly, memo is taken on record and notice to so and so is dispensed with. Yes, next. Both the matters for hearing.
May I request for a date to be fixed? my lord?
It will come. Yes.
Much obliged.
Case number 9, Siddaramaiah. For appellant,
Respondent number 2.
Bhimaiah for R2.
That for adjacent survey number.
Hmm?
For adjacent survey number of the very same village, this number court has enhanced compensation to 50,000 per gunta. Let this matter.
It has to be heard finally.
My lord, beneficiary not made a party in trial court.
My lord,
Maybe remand trial court.
my lord, in earlier case also under the similar circumstances, my lord, this number court has enhanced compensation. Let this matter be, we will try before the local court, my lord, in view of the very same situation.
It is submitted that in respect of the similar acquisition, this court has enhanced the compensation.
Of 50,000 per gunta for the adjacent land.
You filed the IA
I have filed a memo and I have produced the document.
on that. You filed an IA to seeking impleadment.
They
No,
filed.
the honorable court, this honorable court has given permission and it has been implemented.
No, they are on record.
We are on
Already on record.
Did that in similar circumstances, in respect to the same acquisition, already this court in another matter has enhanced compensation. It is submitted, the counsel for the appellant submits the matter may be referred to the Lok Adalat on the registry is directed to place. Yes,
Case number 10, K. Shashikant Prasad for appellant, Chandranath Tariga for respondent.
yes.
And summons was returned here. They have not, and summons returned.
Hmm.
They have not taken. He is not holding wakalat now here.
Why the earlier notice is not served?
Earlier,
That R2 is deceased,
this is the,
and then you have to take steps.
yes.
You have to take steps, sir. When it is received, as per the postal shara, R2 is no more. Land counsel for the appellant shall take appropriate steps within a period of 2 weeks. And as far as R5 is concerned, what happened to R5?
Notice was not,
What happened to the earlier notice?
earlier notice also returned. Not,
No such person.
no such, not in that address you are, he is in now Dubai.
You shall pay the process. You shall take the steps for substituted service in respect of R5. This is matter after 2 weeks. Yes.
Case number 11,
Please.
11. Case number
I am permitted to convert this appeal as a writ petition. The lordship permits.
Your lordship seeking adjournment due to some inconvenience, senior could not come.
No, what is this, what is the impugned order?
Point order is granting injunction to the plaintiff. That was questioned by defendants before the appellate court that appeal is rejected.
Again, you said you filed a MSA.
Yes.
The petition is permitted to, it is submitted that against an order of granting injunction, against that, a miscellaneous appeal is filed. What happened to the miscellaneous appeal is dismissed.
Yes.
Against that, the present MSA is filed and counsel has filed a memo stating that you may permitted to convert the same into a writ petition. Accordingly, memo is taken on record and permitted to convert this MSA into a writ petition. Yes, next.
Please.
Yes.
Number 12.
Petitioner, my lord.
I
I filed an impleading application, my lord, to implead the petitioners in this case. By an order dated, order passed by this honorable court, my lord, that impleading application, I filed the powers of attorney as well as a wakalat. The application may be allowed, my lord. I'll file an amended petition and I'll carry out the amendment, my lord.
Where is that IA?
The IA was filed on 23rd October, my lord.
IA 1 of 24.
Filed on 23rd October.
IA number 1 of 24 is filed. Seeking to impede the. How many number?
8, my lord.
Impede 8 persons.
The beneficiaries to the will, my lord.
Who are the beneficiaries to the will as a proposed petitioners, number 2 to 9. Application is accordingly considering the reason state. I number 1 of 24 is allowed. The petitioner shall carry out the necessary amendments to the contract. Yes.
Hearing on interlocutory application, serial number 13, BK Manjunath.
Yes, sir. Petitioner, please,
Appellant.
my lord. This R8 died on 17/2/2017, my lord. And the LRs are thought to be brought on record.
What is this CP?
Yes, please, my lord. This CP is, my lord, filed under section 24 to transfer the appeal RA number 85/2016, my lord, pending before the learned district judge Davanagere over to this honorable court and club the matter to with 2 RFS are pending before this honorable court, my lord, and dispose of the matter. Brief. Filed OS number.
No, who died?
My lord, R8 died. R8 died.
Notices are already served.
Are already served.
I
R8.
number 2 of 21 is filed to condone the delay of 1,575 days in filing the LR application. Notice is ordered and all the proposed, the LRs of the deceased are served. No wakalat is filed on their behalf. For the reason stated, the delay of 1,575 days in filing the LR application is condoned. Accordingly, IA 2 of 21 is allowed. Consequently, 3 of 21 and 4 of 21 are also allowed, and the abatement is set aside. And so be brought on record as LRs of R8. The petitioner shall carry out the necessary amendment to the cost item.
Much obliged.
Plus this matter next week, either by, not next week, this matter on 26th of March. By the time, the necessary amendment shall be carried out.
Much obliged.
Yes,
Serial
next.
number 14 adjourned, serial number 15.
In serial number 15, I am appearing for respond number 5, my lords.
The appellant, my lord. I filing the application for inter-alia. Delay of IA 1/24, my lord.
R4C, it is not served till now.
Please, my lord.
Await service of notice in respect of R4C.
IA may be condoned, my lord.
Lords, in the meantime, IA 1 to 3 of 24 could be allowed, my
IA
lords. With
application
IA?
respect to
pending, my lord.
IA?
1 to 3, my lords, 1 to 3 of 2024. It is with respect to deceased R1, my lords. That could be allowed.
R1A to
R1,
R1AC.
yes, my lords, that could be allowed.
R4C is in respect of the next petition.
Yes, my lord. In respect
I1
of
of 24 is filed to condone the delay of 86 days in filing the LR application. But the counts for the petitioner and the counts for the respondent. For the reasons stated, I number 1 of 24 is allowed by condoning the delay of 86 days. And also, I2 and 3 are also consequently allowed within 10 days. The necessary amendment shall be made to the cost title. In respect of I4 of 24, notice is not served on R4C. This is matter after service of notice on R4C.
My lords, subsequently with respect to R4E, it is stated as refused, my lords. That
As
could
far as
be-
R4E is concerned, the same is the notice, the cover returned with the postal error refused amounts to team service of notice.
Much obliged, my lords.
Cell number 16. Mohan Kumar T.
Appearing for respondent number 2. Bill, my lord, for seeking enhancement of compensation. But the reference court, my lord, awarded.
There is a delay of 56 days.
I will not claim, my lord, the interest. Kindly
You
condone the-
filed objection, my lord, for delay.
When he is not claiming the interest, what is the difficulty to you? I number 1 of 24 is filed to condone the delay of 650 days. The respondents have filed their objections. This court has perused the reason stated for the delay of 656 days. It's a case of compensation. And considering the interest of both the parties, this court deems it appropriate to condone the delay of 656 days on the condition that the appellant will not be entitled for interest for the delay of, for.
Your Lordship,
656 days.
I am filing memo of appearance.
Memo of appearance should be filed here or in the registry.
Krishnala.
Yes.
For admission matter, cell number 17. Vidyasagar. AC Manjunath for respondent.
Yes.
A petition for transfer of MC number 105 is pending before the Chikballapur. Two first additional
But
family.
that's not the, who filed the transfer petition?
Wife has filed their transfer.
From where to where?
From Chikballapur to first additional FC, where there's one more case pending.
Chikballapur to?
First family court, Bangalore. Additional family court, Bangalore.
When is, which year is the MC?
MC is of 2023.
2023.
14/9/23 MC, that is for the on the ground of priority, which was filed by the petitioner. And this 105 MC number was filed on 23/11/2023. That is for conjugal rights, which is pending before the Chikballapur court.
Now you're seeking transfer from Chikballapur to Bangalore. Who filed it in Chikballapur?
Husband filed in Chikballapur.
Yes, but in Bangalore, what did you file?
Divorce petition under.
When is that?
That is on 14/9/2023, September month. Subsequently, they filed on November month in the same year.
First you have filed in Bangalore,
has filed.
later he has filed in Chikballapur. Yes. Who appears for the respondents?
AC Manjunath.
Why his name is shown though Wakalat is not filed? As for the proceedings, the appeal, the undertakes to file. The notice on the earlier, the coordinate bench of the court had observed, as per the order dated 17/2/2025, is recorded that AC Manjunath undertakes to file wakalat for the respondent and seeks time. Even on 10/3/2025 is also no, there is no representation, nor any wakalat is filed. The notice as per the office as per the office note, the service of notice on the respondent, the acknowledgement is awaited. List this matter after service of notice on the respondent. Yes.
Cell number 18. Exceed my appellant.
Yes, my lord. Yesterday the matter had come up, my lord. By mistake, my lord, I furnished the number criminal petition, CP, my lord. It is criminal petition 1335, my lord. It should have been tagged along with the other. That could be clarified, your lordship.
No, both are here now.
Yes,
Yes.
there are two matters. One more matter, my lord, it was classified as criminal petition 1335. My lord, may.
We'll decide these two that will follow. We'll pass orders on these
No,
two.
my lord, no, yesterday my lord wanted to pass common order, my lord, in all the matter.
Yes.
That's the
Next,
reason,
that,
your
that
lordship.
matter also on Friday along with that.
Yes, your lordship.
You the take that number.
Yes,
All the
criminal-
three matters on Friday.
Criminal petition.
No, if it is a criminal petition, that's before the other court.
In the notice has to be ordered, my lord, in that matter. In this also in one case, my lord, notice is required to be ordered.
In this case,
Yes.
two matters are before this
Oh.
court. Advocate is appearing. We'll decide these two matters.
Yes, my lord.
Argue.
Yes.
You the file.
Yes.
Appearing respondent, madam, kindly pass out.
Ask him to come. At 3:50, no passover. Yes,
Seniors will come.
yes, CP,
Yes. It's CP, it's a 475.
5
It's a GNWC case, my lord, which is filed before the Vascote, my lord, by the husband.
filed where?
Filed before Vascote court, filed before the learned senior civil judge and JMFC Vascote.
Was quoted.
Yes, ma'am. In GNWC 37 of 2023. Where
Which place you want?
Vascote, my lord. To Maddur, my lord.
Was quoted to Madhu.
Maddur, your lord. Maddur, there is a family case. There are two cases are pending, my lord. In Maddur.
Was quoted is where?
Vascote is this side, your lord. Near after Kyarpuram and other thing.
No, it is in Bangalore. Near to Bangalore.
Near to Bangalore, it is near to Bangalore.
What is the distance?
Distance is 40
40
kilometers.
40 kilometers from Bangalore.
Bangalore.
That is 475.
Yes, your lord.
Then what is 476?
476, my lord, is OS, my lord, got filed by the tenant, my lord. The property where I have shared the amount, your lordship, for the purpose of construction of the building. My father-in-law and mother-in-law, my lord, tenant rented the premises. Where, my lord, tenant has filed a suit against us. Got filed by the husband, your lordship. That suit is also pending before the
Why the civil suit should be transferred? Even a civil suit also convenience of the wife.
my lord.
In respect of civil suits also convenience of the
But
wife.
she can't go, my lord. She can't go there, your lordship. There is a threaten, my
The
lord.
civil suit
Yes.
is filed as per the jurisdiction. Civil suit is filed as per the jurisdiction, which has nothing to do with your matrimonial disputes.
That's correct.
Whether
my
it is a collusive suit or not will be decided
Yeah,
later.
that's correct.
As one of a third party has filed a suit.
The tenant has filed a suit, my lord. Got filed this, got filed by the husband, your lordship. That's the reason, your lordship. And there is no proper care to take, my lord, in the Vascote, my lord.
Civil suits cannot be
Might have
transferred
known.
on that ground. These are not matrimonial proceedings. Then coming to 475, let's look at 475.
Yes, 475. 475.
PNWC is filed in the year 2023.
Yes, your lord.
She has been contesting that matter before the court. What is the stage of the proceedings now?
No, the territorial jurisdiction point, my lord, the case is argued, my lord, and the matter is required to be ordered to be passed, my lord.
But the court passed.
In the
or not?
meantime, my lord, the order came to be passed without considering the objection filed by the wife, my lord, to hand over the custody of the second child also. Thereafterwards, we filed a petition.
I remember.
My
that
lord
court
knows,
case
my lord.
Came before
Yes,
me.
yes, your lord. I have produced the copy of the order also, Annexure B. As per the order of this court, things are going on, my lord, without smoothly, there is no problem at all.
Please come.
page 28, my lord, is your lordship.
CP 475 of 2024 is filed seeking transfer of JNWC number 37 for 2023 pending on the file of the senior civil judge and JMFC at Hoskote to the Court of Senior Civil Judge and JMFC Madur. The facts of the case are like this. The
Petition is at page 35, your lordship. 35. Page 28.
the events and dates should have contained
I have filed the IA, orders passed on IA, my lord, Annex 8 to show that the.
JNWC 37 of 2023 is filed by the husband seeking custody of the child. Custody of the second child. The parties, in view of the differences between the husband and the wife, the first son is residing with the husband and the second son is residing with the wife. It is the case of the wife that she is staying along with the son at Madur. And it is difficult for her to travel all the way to Hoskote to attend the pending JNWC proceedings before the court. And the distance between Madur and what is the distance between the two?
Maybe 120 kilometers total, my lord.
120
120 kilometers.
120 kilometers, and it is difficult for the wife to travel. Learned counsel appearing for the respondent husband submits that, in fact, the wife is working in Bangalore and the child is
Studying in Madur, madam.
residing along with the grandparents in Madur. When the wife herself is staying in Bangalore,
She
the
is
wife
not
is
staying-
working in Bangalore. Question of transferring the proceedings from Bangalore to the case shall not be transferred from Hoskote to Madur. It is submitted that the SEMC GNWC is filed in the year 2023 and she has been pursuing the matter and she's appearing before the court. And now this application came to be filed on 27/2/2025. And this application came to be filed.
No, she never appeared, my lord, before the Hoskote, my lord. Order came to be passed, my lord. Lawyer was engaged, my lord, that's all, my lord.
She is pursuing the matter before the courts at Hoskote, and now this application is filed. Having heard the counsels on either side, there is a material on record. The wife is working in Bangalore and the husband, along with the person, is in Hoskote.
No, our son,
And-
my lord, son is in Mangalore, your lordship. He is admitted to
The-
the college, your lordship there.
He's taking care of the
Correct.
son.
No, I'm not saying that. I'm not saying anything.
Is taking care of the first son. And another case is also pending at give the next matter.
OS 194 of 2022.
OS number
194 of 2022.
194 of 2022 is filed by one Nagaraj
Tenant of the
against the petitioner herein.
petition and
seeking
husband,
the
your lordship. Petition and
relief
husband.
of seeking a relief of permanent injunction restraining the defendant from interfering with the lawful possession and enjoyment of the scheduled property without the due process. In respect for seeking transfer of the said case from Hoskote to Madhur, CP number 476 of 2024 is filed. Even the similar reasons were stated, that it's difficult for the wife to travel to Hoskote for prosecuting the same, hence the matter may be transferred. In the GNWC, already on the maintainability of the matter, the arguments were heard, and even an order is passed.
Not yet passed.
That they are waiting for the orders in the same. And this civil suit that is
Regarding
filed
to-
by a third party, that is OS number 194 of 2022, cannot be transferred, taking into consideration the convenience of the wife. When the said matter cannot be transferred, when it is pending before the courts at Hoskote, there cannot be any difficulty for the wife to appear before the court in the pending GNWC matter also. In that view of the matter, this court finds no reasons to transfer. Accordingly, both the petitions are dismissed.
Last occasion, your lordship said that, my lord, yesterday, the matter could be transferred to Bangalore, your lordship said. Bangalore court itself.
I thought it is in Bangalore.
No, it is.
It's not, that's why I asked, I was under the impression that is in Bangalore.
Yes.
That's why that also will be transferred.
Because he has to travel from here to Hoskote, my lord, then to Madhur, your lordship. That's the whole difficulty. Because child will be there, that's the reason.
No, but civil matter, we cannot.
For civil matter, let us not go. So far as GNWC is concerned, your
At
lordship.
least convenient to both of them. At least one of them will be at one place. Why neither, if it comes to Bangalore, then,
No, matrimonial case is pending before the Madhur court, your lordship. Filed by the wife, your lord. And one matter, other matter, my lord, which where the,
then both the matters to Bangalore,
please, your lordship.
both the matters to Bangalore then. We'll ask them to file a petition for, then we'll keep this matter pending. Let them file a petition seeking transfer of what is
Let them
pending.
file, no problem. Let them file,
Come up with a
please keep the
transfer
matter pending.
petition
Yes, my
Seeking
lord.
transfer of
Yes, my lord.
the matrimonial matter pending at Madhur.
Yes, ma'am.
So that matter and this GNWC,
yes.
both will be transferred to
Yes.
Bangalore.
Let them file, your
Wait,
lordship.
so
Let us keep
this
kindly.
order CP 475 of 2024, keep it pending, list this matter after 2 weeks. In the meantime, come up with this transfer petition.
Yes.
We'll transfer it to Bangalore.
Yes, your lordship.
This
That could
second
be
one
done.
is ordered, dismissed, 18.1. Yes.
Till number 19. Somshakaraya.
Dismissed.
In this case, my lord, petitioner's transfer petition, my lord, from Kustigi to Bangalore, my lord.
What is that?
From Kustigi, Raichur district,
Kustagi to
Bangalore, my lord.
Bangalore.
Yes, my lord.
Filed by whom?
Filed by the husband has filed the petition under section 9 of the conjugal rights, my lord. My lord,
Year?
my lord,
Which year?
my lord, this is my lord, MC 68 of 24, my lord. My lord, soon after receipt of the
distance?
summons, my lord, I have filed this. Distance 400 kilometers, my lord. 400.
400 kilometers.
Yes, my lord. My lord, petitioner is residing at the two children.
The present petition is filed seeking transfer of MC number 68 of 2024 pending on the file of the senior civil judge JMSC at Kustagi to the family court at Bangalore. It is, the facts of the case are the marriage between the parties was organized on 27/12/2010 at
At Nilakanteshwara Mangala
Vijaypura.
Kalyanam. Area.
Vijaypura. In view of the differences between the parties, the respondent had left the petitioner and the children in Bangalore and went to Hanuman Sagar. Thereafter, the wife had lodged a complaint against the respondent for the offences under section 498 A and section 3 and 4 of the Dowry Prohibition Act before the Women Police Station. Thereafter, on 15/10/2024, the respondent had filed MC number 68 of 2024 before the senior civil judge and JMFC at Kustagi for restitution of conjugal rights under section 9 of the Hindu Marriage Act. Any children out of the wedlock?
Please, madam.
Children.
Children are with me, madam.
How many? 1, 2?
Two children, madam.
It is stated that in the wedlock, they're
Two
blessed
female
with 2
children.
children. And those 2 children are staying along with the wife. the distance between both the places is about, she's residing in Bangalore, and for attending the case, she has to travel 400 kilometers, considering for 400 kilometers. Then council submits that, considering the inconvenience to the wife and the fact that she's taking care of the children, the MC, pending MC, on the file of the family court at Kustak, we may be transferred to Bangalore. Though notice is served on the respondent, no wakalat is filed, considering considering the submissions made on behalf of the petitioner and the fact that the distance between Kushtaki and Bangalore is 400 kilometers, and the wife is taking care of her 2 children, and the inconvenience that is being caused to the wife. This court deems it appropriate to transfer the petition. Accordingly, so-and-so is withdrawn and transferred to so-and-so. Allowed. Next.
Serial number 20, Sunil Kumar BN.
Yes.
For petition, my lordship. Petition the wife, my lordship. I filed a transfer petition from Chikmagalur to Bangalore.
Where to where?
Chikmagalur,
Chikmagalur to
Bangalore.
Distance?
Distance about 250 to 70 kilometers. 270 kilometers.
When is the MC? MC is of which year?
24, my lordship. 24, not 125 maintenance. 2024.
The present petition
the
is
two
by
petition, ma'am.
seeking transfer of MC filed on the file of the court at Chikmagalur to Bangalore. It is submitted that the wife is a resident of Bangalore, that the distance between both the places is 270 kilometers. Considering the same, there shall be stay of all further proceedings till the next date of hearing. The petitioner shall serve the hand summons on the counsel appearing for the respondent before the trial court and file a memo to that effect by 26th March, or else the stay granted by this court stands vacated without further reference. Yes, next.
21, same connected.
Correct, madam. GNWC.
Same. Yeah, what is this?
GNWC, filed by the husband.
GNWC. Yes, next.
Serial number 22. Serial number 22.
For petitioner, my
Then
lord,
we
wife's
don't-
petition from transfer from Gadak to Bangalore. The
Gadak
distance
to?
is about, Gadak to Bangalore, my lords.
Hmm.
The distance is about 417 kilometers,
MC which year?
2025.
The petition is filed by the wife seeking transfer of the pending MC from family court Gadak to Bangalore. It is submitted that the distance between both the places is about 400 kilometers and is difficult for the wife to travel. Accordingly, they shall be stay of all further proceedings. Same dates, hand summons.
Serial
Yes.
number 23.
Or else the stay granted by this court stands vacated. Next 23.
23, Maruti GB.
Please, madam.
My lord, this petition is filed by the tenant, my lord. My lord, as on today, my lord, the petitioner has paid the entire arrears.
Where is the respondent?
I don't know, my.
Yes.
Vivekananda.
Letter for respondent.
Hmm.
My lord, the order has been passed by the principal civil judge. So the revisional court is district court, my lord. As per 47 of.
I will address the argument on next date of hearing. On that point, my lord, I will address the argument. Kindly grant a week time.
What is the time for that on a jurisdiction point? So which court has passed? Again, is that where the,
I will.
the-
Kindly.
no, for
grant
that
a-
only the matter is coming before the
Correct.
court.
Today, that's only, my lord.
Argue.
Section 46 of House Rent Act.
Correct, my lord. Revision court is the district court. I agreed, my lord.
Then it
But
has
my-
to go.
But my lord, the trial court, without considering the defense of the,
What is this argument? Where you have a remedy, there you have to go.
please, ma'am.
Because court has done some wrong.
Liberty
there's
may
no
resolve to the
interfere
petitioner,
in
my
all
lord.
that.
Liberty may resolve to the petitioner to
The
oppose the competent court.
Learned
And
counsel
also
appending
delay
to the
may
respondent submits that as per section,
46
46.
of the rent act.
as per section 46 of the
Rent.
Rent Control Act. The revision, when the order is passed by court, by the second additional civil judge and JMFC at Davangere, the revision lies to
District court.
district court. But the same is filed before this court. Learned counsel of the petitioner seeks liberty to to approach the district court accordingly.
My lord,
The petition is,
delay, my lord.
once the liberty is given, that is deemed that the delay is condoned. And so
Point made.
petition is at liberty to approach the jurisdictional court. Yes.
Obligation.
Bill number
Kindly
24.
note on one point, my lord. Delay may sir.
Mr. Counsel, when the liberty is granted without anything, that means the same.
Please.
Yes, to your satisfaction, order cannot be passed.
Bill number
Yes.
24, K. Shashikant Prasad, for appellant.
Temple administrator.
Petitioner
is a temple
Please use the mic. I'm not able to hear you.
Petitioner is a temple administrator. He filed a suit for possession and mean property, Your Honor. It was decreed. Later they filed appeal and it was remanded. The plaintiff filed suit for possession. Defendant is monthly tenant under plaintiff. The scheduled premises situated in Mudabidre. The plaintiff issued.
We'll hear it some other day. This is matter on 19th of March.
Cell list number 3, cell number 1 adjourned, cell number 2, Suresh M. Latur, for appellant, MP Srikanth, for respondent.
For the appellant, my lord. Clement.
There is Mr. MP Srikanth.
MP Srikanth,
Yes, no representation for the respondent. This is matter on 3rd of April. Yes.
cell number 3. Cell number 3, Suresh M. Latur, for appellant.
Yes, my lord.
HP
I am the appellant, my lord. I have filed this appeal for enhancement of compensation.
Yes.
Here in this case,
What is the amount granted?
Better you are asking to hear.
Are you ready, Mr. Rathur?
yes, I am ready. I am ready, my lord.
Better
The
you are asking.
compensation has been awarded 2,78,485.
Is it a case of injury?
It is a case of death, my lord.
The case of death. What is the age?
Age is 30 years, my lord.
Occupation?
Occupation, he was a granite worker, my lord. Granite worker.
How much is the income according to him?
6,000 rupees, my lord.
How much the court had taken?
Court has taken a 2,628 rupees, my lord.
When is the accident?
Accident is taken place on 16/9/2006.
What is 2000?
2006, my lord. It is a WC case. It has to be taken 4,000 rupees, my lord.
4,000.
As per the central government notification.
Mm.
Minimum.
Let's see the calculation, how it is done. Is
Yes,
it correct? As per the
My
notification?
submission, I am questioning the jurisdiction of the authority to pass the order. Because there must be a relationship of the employee and employer. The second appeal you are asking. You have challenge. No material has been placed.
No, according to you, there is no employer-employee relationship. Now let's go to those both the issues.
Please.
How the court dealt with regard to the first, the employer-employee relationship.
Yes.
This
There
is
is
in
no material
Kannada.
has been placed on that order.
This is in Kannada.
Yes, my lord.
One translation,
Where is it? Where is the translated copy?
not a translation.
This matter on 3rd of June.
Cell number 4, Suresh M. Latur,
Yes, my lord. Ready, my lord, in this case.
O Mahesh for R2,
Yes, Mr. Mahesh.
O Mahesh sir,
In this case, my lord, he has become a blind, my lord.
O Mahesh, sir, O Mahesh sir,
Yes, this matter also on 22nd of April. No counsel for the appellant is present, no representation for the insurance company. Yes,
Till number 5. Till number 5,
I appear for appellant in this case.
Satish HK.
who appears for the respondent?
Respondent Uma Devi
is
appearing for respondent.
Hmm.
Advocate Uma Devamma. He told that she could not appear
Connected.
before this court today for the
No, where is her name?
Uma Devamma.
Uma Devamma.
Yes.
Hmm.
That is the reason she wanted to make submission in the morning, but she could not make it. She told me to take this matter on Monday, madam.
Yes, Tuesday.
Tuesday, much okay. Along with connected.
18. Till number 6,
Appellant.
Yes.
P. Purandara.
First case 8631.
As for the books. Scribbling, as I asked, no, with the lines. Hmm. Yes,
Not in the serial 8631, madam. Page number, in page number 20, madam.
is it a case of injury or?
Injury,
death?
madam.
Ravi Sampath.
Injury case, madam.
It's a case of?
Case of injury, madam. In
Oh.
first case. the
What
injury-
is the compensation granted?
My lord,
I want all of you with the basic details. That's what I ask any day.
1,65,000, madam.
1 lakh
65,000.
is the amount granted.
Yes, madam. Yes, madam.
Case of injury,
Injury, madam.
any disability,
My lord,
any disability?
disability is there, madam. Doctor has examined, madam.
What was the disability as per the doctor?
As per doctor,
17%.
17% whole body. madam.
17% to the whole body. How much the tribunal had taken?
Tribunal has considered 10%.
10%. madam.
When doctor said 17, court had taken 10%.
10%.
What is the salary?
Cooling, madam.
5,000 rupees is considered.
5,000 is considered. Which year is the accident?
2010.
10, madam.
23/5/2010. It should be 5,500.
5,500. Yes. Let's come to that calculation.
Like, it should have been 11.33% disability. The limb disability, the doctors assess at 33.7. So
With
the whole
1/3
body
of it.
disability comes to 11.33
Instead of 10, it should be 11.33.
instead of 10%.
Let's go to that calculation. What are the injuries?
He has suffered
Fracture of,
fracture of femur,
One fracture.
only one fracture.
How much is granted under the head of pain and suffering?
30,000.
30,000.
We'll grant 40,000. Then loss of income during the later period?
10,000.
Only 10%. 10,000, madam.
The 10,000.
How many days he was in hospital?
21 days, madam.
We'll
21 days.
consider 3 months, 3 into 5. That it will come to 16,500. Then
Loss of amenities 10,000.
attendant nourishment and all.
2,000 rupees.
2,000, madam.
He was 20 days in hospital.
21 days hospital.
We'll grant 20,000 for that. Then where is the table? Pain and suffering, medical expenses?
Medical expenses.
Including medical expenses, 2,000 rupees is granted. The lordship
Medical
will get the
expenses,
table at
other
page
incidental.
number
Medical
15,
expenses, 2,000 is granted.
Page number 19 of the judgment. your
Yes,
lordship
I'm
will get
looking at it. Loss of future earning capacity.
1,08,000.
Future, what is future medical expenses? 5,000.
5,000.
5,000.
Are you disputing on this?
No, madam.
Future medical expenses, 5,000. Now we are only on loss of
Future earning.
Future earning capacity.
future earnings. So if you take 5,500 into 12 into, what is the multiplier?
18.
18, madam.
18 into 11.33.
33.
It comes to 1,34,600.
1,34,600.
My lord, and also loss of communities only 10,000.
Loss of amenities. 10,000 is granted.
%10 negligence is deducted.
1 minute. It comes to 2,38,100. Please come.
Let him do this. 10% contributory negligence is
It's
fixed.
fixed. What is
There
on
are
that?
3 persons traveling on the
There is no
motorcycle.
negligence. There are 3 persons, admittedly 3 persons. Rider, pillion riders, 2 pillion riders.
You are a pillion rider. So 2,38,000 into
10%.
it is, then what would be the amount?
2,38,100.
Less 10%.
2,38,100. 23,000
23,810.
has to be minused.
Yes. It comes to 2,14,290.
2,14,290. All these MFAs with all the facts, I think in a day, 30 to 40 cases easily can be disposed of. But unfortunately, this time I'm seeing nothing is happening.
If we sit together for a while and make a calculation, that will become your.
Even if I have to calculate also, it will happen in 10 minutes. But the problem is like, no, all the matters are messed up. MFA, MSA, 25, 30. I'm wondering how 30 date given matters of file hearing are there in a day. Because in the earlier roster, when I was there, I used to dispose of 30, 40 cases in a day. No, in this roster, nothing is happening. And the court is also not satisfied with the way the work is going on. No, and 13, 14 matters are pending. That's why I request all of you to give the 13, 14, 12 oldest matters. And we will dispose of like in priority, I'll make all of them in first list. Let all the date given matters go somewhere. Because in all the date given matters, nobody is coming forward.
By Monday, we
Please tell all your colleagues also and give them, and I'll make it in the first list. Every day, or else I'll make it a 230 list. So that we'll complete at least 20, 30 disposals a day.
And we'll also try to come with the calculation.
And
Probable
calculation
enhancement.
and more is, I want only 4 details. If it takes 1 minute.
On claim, award,
That's
extra
it.
compensation.
That's it.
Date of accident.
What is the amount they claim? What is the compensation given? What is the salary? According to them, what the court has taken, which year is the accident? That's it. Basic details, and we can do good work.
Yes.
The agreed with, which is the MBC number?
69.
6990.
6990.
Agreed with orders passed in
2010.
MBC 6990 of 2010, dated 26 March 2013. The claimant is before this court seeking enhancement of the compensation It is a case of the claimant that he had sustained a fracture injury in the accident and also sustained the disability because of the injury sustained by him. He had sustained 33 points as per the evidence of the doctor. He had sustained 33.7% disability to the right lower limb and 17% to the whole body. The court had taken 10% as a disability. When it comes to the income, court had taken
5,000.
5,000 per month. And towards the head of pain and suffering, an amount of rupees 30,000 is granted. For medical expenses and other incidental expenses, 2,000. Loss of amenities and future discomfort, 10,000. Loss of earning during the treatment period, 10,000 is granted. Loss of future earning capacity due to disability, an amount of rupees 1,08,000. And for future medical expenses, an amount of rupees 5,000 is granted. Total an amount of rupees 1,65,000 is granted by the tribunal. When it comes to the liability, the court has held that the insurance company is liable to pay the compensation. But as 3 persons were traveling on a motorcycle, the contributory negligence is fixed at 10% on the claimant. Aggrieved thereby, the claimant is before this court seeking enhancement of the compensation. He submits that on all the heights, the amount that is granted with the tribunal is on the lower side and it's not a reasonable compensation. It is submitted that the court ought to have taken 5,000 as the income, 5,500 as the income as the accident had taken place in the year 2000?
2010.
2010. It is further submitted that that the disability, when according to the doctor, it is 17%, court had taken only 10%. And on that count also, it requires enhancement. It is submitted that without any basis, the contributory negligence is fixed at 10%. That is also without any basis. Next para, having heard the land counsel appearing for the insurance company submits that court, considering the injuries, considering the disability, has rightly granted the compensation and no enhancement is required. The claimant is not entitled for any enhancement. Next para, having got the counsels on either side, there is the material on record. As first coming to the contributory, the aspect of contributory negligence, considering the evidence on record, the findings of the court, the court had the order on this aspect is a well-considered one. No interference is conferred. Considering as far as the enhancement is concerned, towards pain and suffering, this court is granting an amount of rupees 40,000, considering the grievous injury sustained by him. This is an accident of 2010, considering the income at 5,500 for 3 months. This court is granting 16,500 toward attendance and nourishment charges for the hospitalization. This court is granting 20,000 towards the medical expenses and the future medical expenses. An amount of rupees 2,000 and 5,000 granted by the court. This court is not interfering. Then coming to the loss of future earning, as this court is taking 5,500, when it comes to the disability, as per the doctor, the total, disability to the limb is 33.7%. Then to the whole body, it would be 11.33. Hence 5,500 into 12, and the relevant multiplier 18 into 11.33 comes to 1,34,600. Loss of amenities, the court had granted 10,000. That also this court is not interfering. In the light of the law laid down in so-and-so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 2 lakh. The compensation comes to 2,38,100. As the contributory negligence that is fixed by the court is 10%, the claimant is entitled for an amount of rupees 2,14,290. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from so-and-so to so-and-so.
Connected matter, one more.
Where is the connected matter? Oh, what are these 2 matters? Oh, in respect of the other
Claimants.
It's not right. These 2 are here. It's already 3:52.
Yes,
A reference
yes.
is, these 2 tomorrow, or the day after tomorrow.
Yes, ma'am.
Other two connected as part heard. If you give the list by Friday, we'll list the matters on Monday.
Please.
So, MFA, all these MFAs shall come in the list on Friday.
My lord, the next matter is.
Friday.
Serial number 7. Please.
Serial number 17, my lords. They appear by the insurance company. O Mahesh appear.
ಮೊನ್ನೆ ಹಿಂಗೆ
12, 13, 14.
Yes, give the dates accordingly. Yes.
My lord, next is 7. This, it will not take 3-4 minutes, that's all.
Reference.
17.
Reference is there.
Please.
Today the court is in 3:45. Is marked on Friday.
Serial number
Remaining
17.
matters, give the date.
My lord.
Court officer, madam.
Madam, ಅದು ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಆಗ್ತೀನಿ ಟೈಮ್ ತಗೊಂಡಿದ್ರು 17 ಅಲ್ಲಿ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು
ಇವ್ರದೊಂದಕ್ಕೆ ಫ್ರೈಡೆ ಡೇಟ್ ಕೊಡಿಸ್ತೀನಿ.
ಅದರೊಳಗೆ
Court officer, madam.
Madam, ಹೇಳಿ.
Serial number 25, ಅದು covered by
Madam,
judgment.
in all other matters, I will assign the date as per the previous court date given matters. According to them, I have to assign the dates. I will assign it.
Okay, madam, thanks. ಇದು Supreme Court judgment covered ಇದೆ, madam. So on short
ಅದೇ-
date ಬೇಕಿತ್ತು.
Madam, whatever you want to submit, whenever case is posted, you come before the court and submit.
Okay, madam. Thank you. Our evening date ನೋಡ್ಕೋಬೇಕಾ, madam?